Good morning. Good morning. Welcome to the Appeals Court. My name is Peter Sachs. To my right is Justice Christopher Hodgens. To my left, Justice Robert Toone will be your panel for all 6 cases today. I would like to say that we will be taking a break after 3 cases. I appreciate everybody showing up on time, but we won't get to the second 3 cases until after our morning break, which I will estimate would occur right around 11, sometime from 11 to 11:15. So counsel parties, if you don't want to sit through the first 3 arguments, you're welcome to go out in the hall, go get a cup of coffee, sit in the room outside where I think you can hear the proceedings without having to be here. If you've been to the appeals court before, you know each side gets 15 minutes. There's no rebuttal. We have read the briefs. We've read the record. We know the facts and the procedural background of the cases, so I would urge those who are arguing to get right to the heart of your argument and not spend time on preliminaries because 15 minutes goes quite quickly. So with that, I will call the first case, number 25P454, Commonwealth versus Scott Tavares.
Good morning, Justice Sachs and the rest of the panel. May it please the court, Keith Kaminsky on behalf of Scott Tavares. This is a simple due process case. The probationer did not receive notice of the evidence that was going to be used against him at his violation of probation hearing. The Commonwealth relied on layered hearsay and poorly labeled videos to attempt to prop up a shaky story that Mr. Tavares had committed larceny through a conspiracy at an Alta in Taunton. Now, if you look at the argument the Commonwealth presents in their closing, they rely on evidence from Stoughton. They call a witness from Stoughton, and their whole case rests on evidence from Stoughton, which was excluded because they didn't provide it to the defendant, and that wasn't on the violation notice. And the other errors flow from that, the ineffective assistance of counsel, questions that open the door to that evidence that was excluded from Stoughton. The other thing I'd like to add, this is a probation case. Probationers, they don't have a lot of constitutional rights, but the rights they do have need to be protected. And this was simply a classic example of a trial by ambush because the evidence that the Commonwealth was, going to use to prove their case was not provided to them before the hearing. Right.
So, but the judge did seem to give defense counsel an opportunity to review am I Stoughton or Stoughton? I'm not sure which is correct, but the Stoughton videos, after he decided to let them in, and then said to defense counsel, listen, if we need to continue this, we can continue this. You can have more time, you have another day. And she said no, and they went ahead, right? So the due process issue, I take your point that they weren't produced to the defendant until that morning, but there did seem to be a decent amount of opportunity for counsel to review the videos, and she didn't really object at that point, right?
Certainly, and that leads into my other issue, which is ineffective assistance of counsel. I understand you're in the heat of a hearing, you just get these videos over the lunch break, and you can't see all the details.
Yeah.
For one, if you look at the labels, a lot of them are all labeled 0415, 0415-5, and if you look at the floor on the video, some of them are gray and some are brown, and that shows one is the Stoughton store and the other one is, the Taunton store, which he had notice of. And if you look at the videos from the Taunton store, there's no scuffle. There's Mr. Tavares walking in, perhaps, and that's it. There's nothing else. Everything else, the identifications, the scuffle.
Well, there was the detective's testimony that he had seen this pattern before, even before the Stoughton videos came in, right? He was sort of saying, I've seen this pattern, I've seen this sequence of events happening, and here's what happened in the Taunton video, right?
Yeah.
Can I just ask about the ineffective assistance? It's really hard to establish ineffective assistance on appeal without affidavits and a hearing and things like that. And I'm trying to sort of figure out exactly what did defense counsel do wrong. I understand that the outcome was bad because the Stoughton videos came in, but what exactly did she do wrong in, she was trying to undermine the connection between the defendant and the woman who was taking objects at the store, but how exactly did she kind of cross the line into sort of clearly, performance below the line that we expect of defense counsel?
So I think defense counsel wasn't worth their salt here because they got greedy. The Commonwealth had, put in their evidence, they'd finished direct, and their case was, I watched some videos. There's no video that, I watched one, but I didn't bring it today, that shows a scuffle. And I'm alleging there's some conspiracy to steal some conditioner from an Ulta with 3 people. But they didn't walk in together, and, that's just what the police detective saw. And I would submit, that doesn't get you over the bar.
Defense counsel should have done cross.
You should have just stopped there.
Stop, okay, no cross, your evidence is inadequate, I'm just going to go on that. So the idea of going to any kind of cross-examination of the detective, that was the ineffective assistance.
Yes, that's the moment that counsel was ineffective.
Yeah, that's a tough call for us to make, right? If this is a different case and defense counsel hadn't done cross, gosh, maybe that could have been ineffective. It's really hard to make these judgments. I see what you're saying, that she would have been better off under the circumstances not doing anything, but it's just hard to look at the questions that she asked and say, well, that's really clearly below the line of proficiency that we expect.
I would submit, at the end of the Commonwealth's direct, they did not have enough evidence. And then defense counsel's questioning kind of provides a roadmap to finding a violation. Because without that, there's no connection, there's nothing showing a conspiracy, and there's no allegation that, Mr. TAVARES picked up anything in the store and stole it. I mean, the testimony was he walked in the store and got thrown on the ground.
Yeah, but that struck me as a perfectly appropriate question that was asked by defense counsel. That, all right, so you saw the female, but, and I think this is where it was on page 29, and in these instances, there weren't 2 men with her. She was just by herself, basically. There weren't the men that you saw in the video with her. So she's just, emphasizing the point that the woman's there alone. So that seemed to be a fair question to ask. I'm not even sure it really opened the door, like the judge said. It seemed more like the judge just changed his mind and realized, oh, maybe I shouldn't have excluded this. How's the lawyer supposed to anticipate that?
Defense counsel has a difficult job, and they have to balance, is the juice worth the squeeze? Is the questioning worth it, when the Commonwealth has presented such a weak case? And I would submit in this case, it clearly was not worth it, and they should have just asked for a required finding with no cross-examination.
The question that counsel asks on cross-examination is about the prior incident from which Detective O'Connor recognizes the woman. Is that correct? This is again on page 29 of the transcript. It's not about what you see, what Detective O'Connor sees on the Taunton video. I'm sorry, and if I misspoke, I apologize. It's about, the counsel says in those instances, there weren't 2 men with her. She was by herself, basically. There weren't the men that you saw in the video with her? Is that a question about the incidents in which Detective O'Connor had previously seen the woman?
From defense counsel's perspective, that would have been unclear because the violation notice was for Taunton. This just shows the prejudice of adding the evidence from Stoughton to this case.
Well, and the detective's response to the question that Justice Sachs points to is, well, in one there was, in one there wasn't, right? And so she got some helpful evidence, saying there was a prior incident where the woman was involved and no other men were, but then there was one incident where they were. That happened to be the Stoughton incident. That comes in. and everything kind of goes south after that, right?
Certainly.
Yeah.
Could you have filed a motion to vacate the violation of probation with an affidavit from counsel, maybe explaining what she had in mind?
It could have been pursued that way, but I would submit in this case, it's clear on the record that there was nothing to be gained with cross-examination. And, I know the Commonwealth disagrees with that, but really the notice issue is kind of what gives rise to this whole ineffective thing. Because, if counsel had time to investigate this, she could have pointed out, the lack of producing the video of the scuffle in Taunton, which is what he had notice of, and point out the differences between how the videos are labeled and what they actually show, because, I would submit it's a little dishonest to label videos from Stoughton, which is on the 14th, with a date that looks like the 15th, but, maybe the court doesn't view the metadata or the labels on the videos. And I would just say that, the prejudice the defendant suffered was he couldn't actually prepare a defense to the evidence he was going to be up against at the violation of probation hearing.
Did counsel know the answer to the question she was asking? Did she expect a particular answer based on having reviewed the videos?
I expected she was looking for just an answer about Taunton. She wasn't trying to get into the Stoughton incidents. The other thing I'd point out, Detective O'Connor's testimony, it's really just based on layered hearsay. There's some videos from the store. They get uploaded to this Aurora system. They go out to who knows who they go out to, and they give him some identifications, and he goes with them. And then he says, I've charged Bianca Cruz before, and that's from the Stoughton incident. So, I mean, really, they wanted to make the violation of probation hearing about the Stoughton incident, but that's not what they gave notice of. They gave notice of, the Taunton incident, and that's what the hearing should have been about.
The judge said, I think, any doubt that I had about whether these three were working together was dispelled by viewing the Stoughton video, which suggests to me that he was possibly prepared to find by a preponderance that they were working together in the Taunton video, even without having seen the Stoughton video. Could the judge not have found by a preponderance of the evidence that the defendant was part of a scheme to commit larceny in the Taunton story, based just on the evidence about Taunton?
The defendant would submit there wasn't sufficient evidence at the close of the Commonwealth's direct. I mean, the evidence they presented was essentially videos of people walking into an Ulta store and a detective saying there's a conspiracy for a larceny, because one of the people I know is like a known shoplifter. And I would submit, that's not enough evidence to take away a probationer's, limited liberty interest, their constitutional rights.
Is it accurate to say that the probationer has served the sentence that was imposed after the violation?
Correct. He's
By
completed
now?
his sentence.
Yeah. So can you just tell us essentially why the case isn't moot?
It's not moot under Commonwealth v. Pena 2012 because this is a constitutional issue. I mean, this is a lot like the Maggio case where basically they give notice of one thing and then the Commonwealth comes and tries to prove something else. And, that violates any probationer's rights. 70% of the people, under corrections, they're on probation. And, they have, limited rights because they're on probation, but still they need to be protected and, their due process rights need to be defended.
Well, but even if there was a violation, what relief could this court offer? I suppose we could, if we agreed with you, vacate the finding of violation, and I don't know if we can vacate the sentence. I mean, the sentence has been served, but what is the meaningful relief that we could offer if we agree with you?
You know, if the sentence is vacated, it just leaves Mr. Tavares with a better record, and that'll, you know, make it easier for him to secure employment, housing, things like that.
You said a case that I couldn't quite follow. What's the case on mootness that you cited?
That would be Pena. Pena.
P-E-N-A?
Yep.
Okay.
Is that in, I don't see that in your table of authorities. You have a citation to that?
I just have the Pena. It's a SJC case 2012.
Seeing no further questions, unless you have anything else to say, we'll take it there or leave it there and hear from the Commonwealth.
Defendant rests on its brief. Thank you.
Thank you.
May it please the court, ADA Bryn Morse on behalf of the Commonwealth, asking this court to affirm. I'll start with the first issue and then move to the second. So on the ineffective assistance of counsel, what we're looking at is from counsel's perspective, at the time that counsel made the decision to cross-examine, whether that was a manifestly unreasonable strategic decision. And here it was not. Counsel's cross-examination was a well-calculated series of questions to point out that the evidence that had been presented displayed less than ideal amount of connection between the probationer and the person who was physically collecting the items. And that was counsel's defense at the probation violation hearing, and so it was reasonable to solicit clarifying evidence in support of that defense, which is what counsel did here.
Can we tell, did defense counsel have a basis to ask that question? I mean, did she know that she would get a decent answer if she asked that? I mean, asking the question, you know, in prior instances, were there men involved with this woman? I mean, it's one thing to ask that question and hope you get a good response, but is there any reason to think that she thought she would get a good response instead of kind of the mixed response she actually did get?
I'm not sure exactly which question you're referring to, but the defense counsel's cross-examination was just a series of questions about, did this video show these people entering together, and those types of questions that I think were very directed towards this incident.
Yeah, I'm thinking about the question on page 29. And in those instances, there weren't two men with her. She was just by herself, basically. There weren't the men that you saw in the video with her, the Taunton video. So the idea is that she's saying the detective saw other videos with just this woman, and there weren't men there.
So I think
We know that's not true from the Stone videos, but was there any other basis to think that would be true?
No, it's kind of not true, but it also kind of is, because in all of the videos, even though they might appear on camera technically at the same time in the Stoughton videos, they're not walking in together or the female accomplice is not interacting with the two men at all in any of the videos. So I think even that question was designed to elicit an answer that was, no, they weren't walking together ever, because they weren't, and they were no doubt very intentionally not interacting with each other when they were on the store in either of the incidents.
Certainly you acknowledge that the Stoughton video coming in was very unhelpful to the defendant's case, right? Because it showed this kind of pattern, you know, arguably really supported the conspiracy element of the same people doing the same things, you know, following the same script as the judge said, right? This wasn't helpful having the second set of videos coming in.
No, Your Honor, I think that was extraordinarily unhelpful for the defense, as was testimony from the detective talking about what he saw in those videos for the Stoughton incident as well. But what we're looking at is, at the time that defense counsel chose to ask the question she did, whether there was a rational basis for asking that question, rather than considering, you know, would she have properly predicted the judge was going to say this opened the door? And to Justice Hodgens' question earlier, I think it is unclear whether or not that question would have opened the door. I don't think it's reasonable to assume defense counsel would have predicted that. And so when we're just looking at it from her perspective at that time, I don't think that decision was manifestly unreasonable.
What was the rational basis for asking that question?
To solicit information that the probationer and the female accomplice were not walking around the store together or interacting together in the store.
well, she asks, there weren't the men that you saw in the video with her, meaning the men that you saw in the Taunton video with this woman were not in the other video. That's what she's asking, isn't it?
That's not quite the way I would understand the question, Your Honor. And we don't know exactly what she was going for precisely because this is presented for the first time on appeal rather than through a motion for a new trial, which is still the proper procedure and even in a probation violation proceeding. But in either event, the whole reason that the videos were excluded was precisely because probationer's counsel didn't watch them before the hearing. And so if she had seen these videos, they wouldn't have been excluded in the first place. But because, even though she was provided these videos along with the other videos the morning of, she elected to watch just the videos from the Taunton incident, that's why they were excluded in the first place. So she wasn't aware of exactly what they did.
So if she had watched the videos of the Stoughton incident, would she have asked this question?
I don't know whether or not she would have asked the question, but...
Would it have been rational to ask this question?
Yes, because the Stoughton videos would have already been in evidence at this point. So the whole reason
But the Stoughton videos clearly show that the three of them are in the store. How would it have been rational to ask this question if she had watched the Stoughton videos beforehand?
I think that to your point, Your Honor, I think the cross-examination probably would have been more pointing out that they weren't ever directly interacting with each other. But at that point, if she had actually seen the videos and they would have been in evidence, at that point there's pretty strong evidence of the three of them acting together because it's the same behavior 2 days in a row at two different stores, both creating a diversion for the female accomplice to exit. So at that point, the defense doesn't really have a defense available. So when we're looking at the counsel's decision, either if we're looking at the point where she decided not to watch the videos or at the point of cross-examination, from her perspective, for not watching the videos, there wouldn't have been prejudice had this cross not came in. And then for her doing this cross-examination, because she wasn't aware of the videos, it wasn't manifestly unreasonable.
She didn't know what she didn't know, right? That's the problem, right? If she had known what she didn't know, then she probably would have, as your brother says, not asked any questions and just sat down because it only could get worse after that, right?
Right, Your Honor. Yeah,
okay.
She wasn't aware of those videos, and then.
The answer to this question, based on the Stoughton video, would be no, wouldn't it? When the counsel says she was by herself, basically, there weren't the men that you saw in the video with her?
So, Your Honor, I think under the way your interpretation of that question, I would agree with you. I think under my interpretation, where she's more asking were the men physically interacting with her, I think it stays the same.
But if that's what she meant, she could have said that. But instead, she asked an open-ended question like, were the two guys, the defendant and this unidentified third person, even in the Stoughton video? Which, if she had watched the Stoughton video, she would have known that they were.
Yes, Your Honor. I think that I agree with you that it's better practice to ask a more specific question, but I don't think that this question in and of itself was necessarily going to something harmful to defense. I think the way it was answered wasn't particularly helpful.
But it was phrased in a way that, if we buy your interpretation, left it open to the witness to answer it in a way that was very harmful.
It certainly left it open to the witness to answer that way. The witness also could have answered that they weren't interacting with each other or the male accomplice and probationer weren't interacting with the female accomplice in the other video as well. But in any event, because we're looking at it from the perspective of what defense counsel knew at the time and just searching for rationality in that decision based on what she actually knew, this was not manifestly unreasonable based on her knowledge.
Well, it's, as I'm reading it, it's funny, you go back and read it a few times, get a different interpretation. It seems to me that she's trying to repair some damage that was done by the Detective O'Connor's prior testimony, where he tried to link the female to some nefarious activities and thereby connect the defendant by association, I guess. And her point was just to say, well, even if there were nefarious activities, the defendant wasn't with her.
Right.
Which seems to be a very logical question. It might not have been artfully phrased, but that aside, what do you say about defense counsel's argument now, which does have some force, that maybe it would have just been better to have no cross-examination and then say, Judge, based on the video, there's no violation here?
I think that that would have been one of several rational decisions that defense counsel could have made at that stage. But because of the standard of review for reviewing defense counsel's actions, we're looking at whether this decision was rational rather than whether this decision was the best decision defense counsel could have made. I agree with you that particularly in hindsight, we can say that defense counsel sitting down would have been the best decision. But the best decision versus a rational decision are two very different standards, and this was rational because it was an attempt to elicit more information that would be helpful to defense and at least clarify information that would be helpful to defense by showing that the detective didn't have any additional knowledge about the probationer interacting with the female accomplice. If there are no further questions.
I'm still not convinced, as you can tell. And I don't mean to be beating a dead horse here, but what possibly could the defense counsel have hoped to accomplish with that question? What answer could she have reasonably expected him to give that would have been at all improved the defendant's position? You can pick that up and put it on the podium if you want.
Sorry, I've got the exact transcript page pulled up.
Yeah.
So the question is, in these instances, there weren't two men with her. She was by herself, basically. There weren't the two men that you saw in the video with her. And they weren't with her in the other videos. They were in the store at the same time, but they were not with her. And I think that this question was designed, perhaps artfully based on what we know now.
You're adding words to what she asked, aren't you?
I don't believe so, but I'm reading it directly. But I might have misread it.
No,
Sorry.
And
in those instances, there weren't two men with her. She was by herself, basically. There weren't the men that you saw in the video with her. I think that question goes to exactly what she's trying to elicit, which is that they weren't walking in together, they weren't interacting together, they weren't behaving as one group.
But there's nothing that the sergeant or the detective had said up to that time that indicated that the defendant was present at all in Stoughton. So why was it necessary to elicit that, he might have been present, but they didn't walk in together? How could that improve the defendant's position?
It emphasizes the defendant's point that they weren't interacting in the videos. I think at this point the judge had some understanding of two incidents happening, and so separating the probationer from the female accomplice in the other incident could be helpful.
But we're up to now, and correct me if I'm wrong, but up to this point on the detective's direct, there's no evidence that the defendant was present in Stoughton, was there?
No, Your Honor.
Okay, so it makes things better for the defendant to elicit that, or to suggest, well, even if he was in Stoughton, he wasn't interacting with or doing anything with the woman doing the stealing, was he?
So
Doesn't that put him at the scene of a prior incident where so far there's no evidence that he was at the scene?
I think that what this does is just emphasizes defense counsel's point. I'm not saying that this is some potential slam dunk in defense's case that didn't already exist, but when we're looking at this, we're just looking at only with what defense counsel knew at the time, whether there is a rational basis to ask this question. And I think the rational basis was to continue to pursue the line of defense that defense counsel was going for and ask questions in accordance with that.
Just to ask one more time, if she had watched the video of the Stoughton incident, would it have been rational to ask this question?
I still think it would have been rational to ask this question because they weren't interacting in the other video. But even if you don't think it would have been rational to ask the question, remember that had she watched all the videos, they would have came in on direct because the only reason they were excluded was not.
If she had watched that video and known that the defendant was in the Stoughton store, would it have been rational to ask this question?
I think it's...
Because if she could have watched the video before and seen that and said, I'm going to leave well enough alone.
So, 2 points on that, Your Honor. The first is that I think it still would have been rational because they weren't interacting with each other in the other video either. And then second, if she had watched the only reason these videos were initially excluded is because even though she was handed copies of videos from both the incidents, she chose to just open the subfolder labeled Taunton, and watch the videos in that rather than watch all the videos that had been presented as evidence. So she chose to forego watching the about 5 minutes of video from the Stoughton incident. So had she seen all of that, it wouldn't have been excluded in the first place. It would have came in on direct, and then we would be in basically the same position we are now. And I think had that come in on direct, she would have still been pursuing basically the same line of cross-examination, separating the probationer from the female accomplice to the best that she could, even though that probably would have been futile because of the strength of the evidence in the case. If there are no questions...
Let me just ask you one quick question. I see we're out of time, but I noticed on page 9, the judge asked for a police report before the break. So before the hearing, he read the police reports. Should he be doing that?
The judge?
Yeah.
The judge should not be considering what he's read in making his determination.
And that's the thing. Now you have the defense lawyer she knows the judge has read the report.
Yes. So. She's aware. Judges are expected to be able to separate out information that might otherwise sway their opinion. There are no questions on the second issue. All right, rest of my brief.
Thank you. Thank you both. All right. Our next case is number 24P647, Commonwealth versus Robert Albert. I would just remind the parties that this is, or the counsel, that this case is partially impounded, so please be aware of that and avoid any additional identifying information.
May it please the court. James McKenna from Mr. Albert. Good morning. With leave of court, I would like to focus on the issue which we addressed in the reply brief, not the other issues addressed in Attorney Cobin's brief. With respect to that issue, one of the first requirements of the first complaint doctrine is that there be a complaint. And the law is pretty clear on that. King was wonderful in terms of a series of notations as to what's needed. And if I could just quickly run through some of the references in King.
We're familiar with what King says.
Yes, Your Honor.
What is the prejudice from allowing this kind of evidence, a statement in a diary, into evidence as first complaint evidence?
This was a second chance to bolster the story.
How is it more prejudicial than if the victim's account to her sister had come in as the first complaint evidence?
Thank you, Your Honor. That could be the reason why this was used instead of the sister's account, which was the real first complaint. In terms of...
just to be clear, there's no dispute that the diary entry was written before the victim's discussion with her sister. Is that correct?
Absolutely, you're
Okay.
absolutely right, Your Honor. The sister spoke to her, as the court knows, and said, "Is he touching you?" And she nods. And that's the first complaint. That's it. That was all that would have been the proper first complaint. Here,
So it's more prejudicial to your client in the sense that it's more damning evidence, but is it unfairly prejudicial?
yes, Your Honor, yes. King and the progeny spoke about how this has to be to another person. And
What's unfair about it being a diary entry rather than a statement to another person? I mean, you know exactly what she said. You've only got one witness talking about it on the stand rather than two different witnesses. How is it unfairly prejudicial?
it goes to the idea that a prior statement by a witness is ordinarily inadmissible because it pumps up the evidence, and that's from cases
That's
like...
true of any of first complaint evidence related by the person to whom the victim disclosed.
And yet the purpose of that first complaint evidence is very limited, merely to corroborate the issuance, the conveyance of that complaint. That's it.
Right.
Not to pump up the story, not to repeat the story, not to say that, well, she said this before in this detail.
If she had sent this journal entry to her sister, that would be the first complaint, correct?
Yes, Your Honor.
It all would have come in.
Yes, Your Honor.
So why is it unfairly prejudicial that instead of the sister getting up on the stand and saying, this is what she sent to me, just having the journal entry go directly into evidence?
It would not be more prejudicial than that. It would be the same thing, because the sister would have said, if the sister could have read that journal entry, but that's not what happened. All the sister got was the nod in response to, is he touching you? That's it. So if the facts had gone as Your Honor has recited them, it would have been no different than this. But that's not what happened. And this is why, with Commonwealth, Your Honor, please.
You know, King puts a lot of evidence on determining what is the first complaint.
Yes, Your Honor.
So this diary entry was before she disclosed to her sister. So focusing on that aspect of King, why shouldn't this come in preference to what she later told her sister?
Because this was not the first complaint, in terms of time, in terms of when this went to another person. The first complaint was a nod to the sister in response to the question, is he touching you? That was the first complaint. This was before. This never was conveyed to another person. As the court well knows, the objective behind the first complaint doctrine is to preclude the unfair attacks on victims based on the idea that if this was real, he would have told someone. That does not work if it goes to a diary. If it's just written in a diary, that's still there. That's still attack, which is addressed at length in King, is still available. In theory, the attack could be then, if this was real, you would have told someone, not just written in a diary that says, on which the cover says, please don't read.
What's the, I mean, I totally take your point. This is not a complaint. It's self-corroboration in a book, right? And I guess I'm trying to understand conceptually, how does this differ from the justification in King, which was the doctrine is to refute any false inference that silences evidence of a lack of credibility on the part of rape complainants, right? So in that sense, the fact that the victim wrote this down to a diary, that seems to align with that purpose, even though it's not a complaint and there's no third-party witness testifying. So I guess I'm trying to understand, like, just conceptually, why doesn't this fit within the doctrine? It clearly is unusual, but why doesn't it sort of carry out the purpose of the doctrine?
Because the disclosure to another person is critical in King. King speaks about a recipient. Twice on page 243, it talks about...
We understand this is different from King, but is it meaningfully different? That's the question. How does a disclosure to another person differ conceptually from a disclosure to a diary?
This would be a prior consistent statement which does not fit the requirements of prior consistent statements, and yet it comes in to bolster the testimony of the victim.
Well, there is a fundamental difference. I think I follow what you're saying. There is a fundamental difference between making a report to a witness versus writing something down. And one thing that stands out to me is when you make a report to a witness that fixes it at a moment in time, where a diary entry is not fixed at a moment in time. You may say it's fixed at a moment in time, but that's just your say-so. But if you tell it to a third-party witness, that witness is going to come in and say, well, in October, she told me. That diary entry could have been prepared in anticipation of litigation.
Absolutely correct, Your Honor. And that goes to the prior law on fresh complaint, which under Green was, it provided that you can't self-authenticate. This is self-authentication by the victim. And that is
You
not...
mean self-corroboration? Is that, or that was the case, Commonwealth versus Peters, which is a pre-King case, but they're talking about you can't have a witness self-corroborate, right?
Yes, Your Honor.
And is that the same principle here, that that's the problem here, right?
Right, exactly. And this is corroboration by the victim of the victim's prior testimony. And it's not fixed in time. It's something which is not consistent with the first complaint doctrine. It doesn't really fit under any doctrine. The closest it comes to is under the prior consistent statement doctrine, but it doesn't fit under that one either. And the law relative to that discusses how it can't work that way.
Well, so that's a way it could have come in, right? So say the victim testifies, then defense counsel gets up and kind of impugns her credibility, says this is a fabrication. Then the diary comes in, right? Probably under that doctrine, right? To sort of respond, it's a prior consistent statement helps to respond to the claim of contrivance or bias, right?
You're right, that would have been exactly the way it would have come in. In fact, I think the Commonwealth began with that doctrine. The problem is, before it can come in, they have to establish that the prior consistent statement was made before the witness had a motive to fabricate.
Yeah.
And so that doesn't fit. So it doesn't work under that. It's hearsay. It doesn't work under that exception. It couldn't work under past recollection recorded here because that would require that the victim not have a current recollection at trial. So it doesn't fit there either. So it doesn't work under first complaint as defined by King.
What about excited utterance? Does it come in that way? Writing a diary is not exactly
That's it.
same as calling a 911 call.
Exactly, Your Honor. It would be hearsay and it doesn't work, but it came in for its effect that way.
You talked in your brief about the prejudicial value of actually having this as an exhibit that goes back to the jury and they can kind of flip through. But to Justice Sachs' point, well, there are times when a written communication is conveyed to somebody else, and that comes in, right? So if the diary had been handed to the mother, then it comes in as an exhibit, right? So that's a similar pattern where you're actually going to have something tangible that the jury is going to be able to look at, right? So why is that prejudicial here, the fact that it was entered as an exhibit?
Because you're absolutely right, Your Honor. In Ravel's, a letter to the mother at the mother's request was written by the victim at the mother's request, was intertwined with the other communication with the mother, and that came in. That would be first complaint. The problem is, factually, this was not given to someone else. This was not first complaint. This was just inadmissible hearsay, and yet it came in over strenuous objection. So...
But it wasn't admitted for the truth, was it? You don't challenge the efficacy of the judge's first complaint instructions, both when the journal entry was admitted and in the final instructions.
Well, the instructions are an improper take on what, and we just define this in the reply brief. I know we're running a little low on time, but the instructions by the Superior Court were the same instructions as in King, but left out the requirement that it go to another party. Just said disclose as opposed to disclose to another party. That's in the reply brief, sort of towards the end.
Okay. Well, I guess the question would be then, if it's permissible to have a writing serve as the first complaint, then you would agree that it's not appropriate to have the instruction say it must have been orally communicated to another person. So whether the instruction is adequate or not depends on the fundamental question you're raising, which is, could the diary entry serve as a first complaint?
It could serve as a first complaint if it had been communicated to another party. That's the key. And if it's not, then it's just something written by a victim who then would be repeating a prior consistent statement without fitting into any of the exceptions or the first complaint doctrine. And that's what we had here. That's the error here.
Isn't a writing potentially less prejudicial to a defendant because it's just a piece of paper? It's not, it's boring compared to the potential testimony of a first complaint witness saying, the victim came to me, she was sobbing, she was, uncontrollably shaking, and she told me all these details, and, it was just awful. I mean, doesn't a writing potentially save the defendant from that kind of graphic testimony by another witness about the victim's demeanor?
It could. It absolutely could, Your Honor. But here, as indicated by pages 20 and 21 of the Commonwealth's brief, which defines exactly what was said, this is a multi-sentence, multi-paragraph, elaborate description of the allegation. If the writing Your Honor was talking about was what was actually conveyed as first complaint, just he touched me, or he's touching me, or something like that, that would not be as nearly as prejudicial as what was actually introduced if it had been told to someone else, but it wasn't. So it's in violation of all of the first complaint doctrine and all the hearsay rules we discussed. With respect to Medellin, the case which the Commonwealth has done a wonderful job bringing forward in terms of the comment by this court that a diary served as first complaint there, that was not before this court. There was no question in Medellin as to whether this was compliant with King. It was, my understanding is that at trial, both parties wanted this in evidence because this was not consistent with what the victim said, and the Commonwealth and the prosecution could attack, the defense could attack on that basis. And it was not, this court did not hold in Medellin that this was okay. It just didn't reach the question. As opposed to in Cruz, where it did address this, and if I can just get the, Cruz speaks about, is permitted to testify about her complaint to another person. That's Cruz. That's what this court held when it reached the question, as opposed to Medellin, where it didn't. And unless the court has any further questions, I'd be happy to rest. Thank you.
All right.
Thank you, Your Honor.
Thank you very much. And we'll hear from the Commonwealth.
May it please the court, Rachel Eisenhower for the Commonwealth. The heart of the question here is, what is a complaint, an expression or a transmission? And if we accept my brother's proposal that it is a transmission, then we have to ask a second question. Is it going to be a completed transmission, even if inadvertent, or is it going to be an attempted transmission, even if it is not received? I would suggest we do not embark on that journey at all, and we leave it to trial judges' discretions to sort out what expressions by a complainant are first in time and are appropriate under the King doctrine.
But the problem is, it's the first complaint doctrine. It's not the first diary entry doctrine.
It's true.
And I went back and I reread King, and it's just chock full, as counsel pointed out. There were at least something like 58 references to witness. So I think Justice Cowan, careful writer, was making it clear that we need a witness here.
They absolutely had the scenario of a witness in mind, but it is not clear to me that they meant it as a prerequisite, so much as it was an assumption based on the common pattern of how they expected it to come in. For instance, even if we accept transmission, it does not always come in through a separate witness. So for instance, if it had been put in through a letter or a text message and the recipient wasn't available, the complainant herself could authenticate it and have it introduced into evidence, and that fact pattern arises as well. So looking to the requirement of a second witness is not necessarily a perfect fit with the question of, is it only transmissions? There's still going to be the problem of transmissions put.
But it does fix it at a moment in time, though, right? Where a diary entry doesn't. So this could be composed in anticipation of litigation, and you can write it up so that it's very persuasive. But it might not be trustworthy. Whereas if you make a report, like I had said before, and a witness comes in and says, yeah, no, she came to me in October and said this. Well, all right, now we know when the report was actually made.
Your Honor,
the circumstances surrounding it.
all evidence, unfortunately, is potentially untrustworthy. That's the jury's job to review these questions, to look at the answers, and to sort out whether they believe the witness, whether they believe the complainant. And it's the judge's job at voir dire to make those factual findings as an initial matter that she did credit that the diary was from a certain point in time, and that time predated the complainant's decision to leave the father's house.
Do you want to, I know for this case, your interest is in affirming the conviction, but does the Commonwealth want this rule ex ante generally? Because you could see cases where there's a very evocative first complaint witness, but it's then established that, well, the victim had a diary and there's some reference in the diary, so the witness is out, we got to go with the diary, right? You're kind of locked in. I could see this as being a very interesting tactic by defense counsel to sort of cut out first complaint witnesses going forward because there's some kind of writing that the victim made to him or herself, right? So I guess I'm wondering if this is, you're asking for a rule that's really going to be counterproductive.
I understand the risk, Your Honor, but in my view, that already is the rule. So I don't feel that I'm asking for something that would hurt the Commonwealth. I feel that this is already an issue within trial judge's discretion under ALVAREZ to look at the complaints to determine which is the first one. And there are circumstances in which a judge can throw out one of the complaints, even, for instance, where the third party was biased or had a motive. There are circumstances in which we do move on to a second complaint for reasons. And I can't predict all the factual situations in which it arises, but just as the SJC did in ALVAREZ, I trust to the trial court's discretion to sort it out on the messy facts of each individual case, including, as Justice Hodgens pointed out, to determine what the point in time is so we can figure out the order of the complaints and what is truly first, and to make the determination, if that's necessary, that it was prepared in anticipation for litigation, which was something that the defense counsel here was concerned about. She raised that, and yet the trial judge heard the voir dire, heard the complainant. She told her that this is a diary from this point in time. This diary was recovered by the police via search warrant about 4 days after the complaint that was made to the sister verbally. So the defense counsel at trial seemed to be speculating that the child may have had an opportunity to return to the home and insert this in the diary, but there really was no evidence of that beyond speculation.
Can I ask about this case from 1999, which is pre-King, but Peters? This is the case that says, you know, the doctrine does not allow a complainant to engage in self-corroboration. And there's a very detailed explanation of why. And of course, King in some ways broadens the exception, in some ways narrows it, but that principle doesn't seem to have been changed. And I guess this gets to your brother's point about complaints are complaints to other people and not sort of the victim self-corroborating her allegation in some way. And I think in those facts it was a little bit different, is her kind of saying, well, I told this person, I told this person, told this person.
So I had read that fact pattern more in line with what the courts shut down in the wake of King, that you can't have duplicative complaints, that the piling on and the multiples. And so for me, that was more of a case about the multiples. But I acknowledge it also mentioned the self-corroboration aspect of it. Now, my reading of King is that King, like the fresh complaint doctrine, it firmly rooted the exception doctrinally in a sort of a prior consistent statement idea, as opposed to the earlier hue and cry idea. It is not the case that we now believe if this was real, you would have told someone. That is not what the science has said as psychology has evolved over the past few decades, particularly with children, but with all victims. That is simply not something we continue to believe is true, that if someone was a real victim, they would want to tell someone. That's no longer the science, and the law has responded accordingly. And King emphasizes that. King recognizes it. I believe Aviles does too. And because of that, that is why we are no longer looking for even a quasi hue and cry, even though it was no longer the medieval hue and cry, she's got to run to someone like with the torn clothing and screaming. But it's no longer even the way we thought of it in the earlier years of the fresh complaint, where you want to be telling someone. The issue is that it's just a form of prior consistent statement. Now, there are differences with that doctrine, and here's where it lies. In a first complaint, there is no trigger. The trigger is presumed. If you look at the jury instructions set forth in King and the model jury instructions on fresh complaint, you're going to see a lot of parallels. You're going to see the jury told that they can't use it for truth, but only for corroboration. You're going to see that the jury is told that they should look to the circumstances to evaluate it. They're going to be told that it's their job to look at the circumstances and to determine the consistency, whether it's the same thing they're being told. Are you hearing the same thing between that one and this one? So really, functionally, they're being asked to do the same kind of examination of the evidence under first complaint that they're asked to do in a prior consistent statement.
So, I mean, it's a good analogy, and I take your point, but the whole point of the prior consistent statement doctrine is that
Rebuttal.
This kind of evidence is really powerful,
Yes.
and therefore we only let it in under unique circumstances
When the door has been opened.
the credibility of the declarant has been challenged, and then it
Exactly.
comes in. And
Exactly.
here it's the exact opposite. It bolsters the declarant's statement from the
I
very
disagree with that, Your Honor. It's not the exact opposite. It's ellipsized. You see, when they decided King, they realized that the defendant does not even have to open the door for this shadow to be cast over the complainant. Because of our culture, because of the history of sex abuse, there is already this existing shadow, and that is in King. That the complainant comes to the stand with this cultural cloud over their head, and therefore King allows this unusual procedure to dispel it, just as if in other cases, the defendant has put the cloud over the complainant's head by the suggestion of fabrication. And that is why it is parallel. The King doctrine is parallel with this prior consistent case format because the jury is doing the same process, and the only difference is that the trigger is different, that the trigger is presumed.
Just can I ask quickly, sort of, Justice Sachs asked about were we to find error, is this prejudicial? Do you make an argument as to it not being prejudicial if it were to be deemed error?
So this was such a fact-intensive trial with so many game time decisions by the judge. It's very difficult to figure out what would have happened differently. Because the defense did cross-examine on other prior consistent statements. The defense did seek to have other portions of the diary in. And so if we start walking down the, if this hadn't happened, what would have, how far do I get to play that? Do I have to just compare this to what this case would have been without it? Or do we have to consider whether this all would have come in a different format anyway? And that's really hard to play out on a case that was this fact-specific and went question by question. They did have other things in here. The victim did testify. But this is the evidence we have. We have the victim's testimony. She was heavily crossed on prior statements by counsel, but counsel was also acting in a world in which she had this ruling that this was the first complaint. So it's very difficult to untangle what the comparison would be.
Conceptually, as a writing never intended for anyone else's eyes, isn't there a probability that the diary will have more details and greater immediacy than an account such as the victim's account here to her sister?
It could depend on the diary. I mean, as Justice Toone pointed out, you could also have a very weak diary entry and a very credible witness. So it really is so fact-specific. I don't think that it is true that diaries are always going to be more lurid than complaints. I don't think it's true that complaints are always going to be more lurid than diaries. It's simply going to be on the facts of the case one by one, and trial judges are going to have to take their evidence the way they find it. But
what about the risk that as a writing it goes to the jury and gets undue weight as compared to the jury's memory of the first complaint testimony?
So
and perhaps creates a risk that the jury will forget about the limiting instruction and take it for the truth.
So currently I'm not aware of any limitation on that in the doctrine currently. I have seen transcripts where trial judges, to mitigate that risk, have had the writings read aloud into the transcript but not sent as exhibits. So I've seen it done, but I've seen it done both ways. And currently there's no requirement. I think that the better rule is to allow the judge the discretion to send the writing in, because particularly in a writing like this, where it's in this person's handwriting, that really is like hearing tone of voice. Seeing handwriting can be like hearing tone of voice in terms of, do I believe this, do I not believe this? So I think that there's a human factor I wouldn't want to edit out. I think it would be helpful for the jury as the ultimate judge of credibility to be able to see it in its original format, to look at, does her handwriting shake a little? Does she quaver? I think that is something that might be helpful for them the same way hearing tone of voice might be. And if you're worried about the limiting instruction, you could staple the limiting instruction to the front of the exhibit to remind them. That would be a practical option. Again, these are just management things going forward that could just be within the discretion of the trial judge too.
Does the judge have discretion with respect to the current oral first complaints to third parties to limit the amount of information that comes in about that complaint? I mean, suppose there is a half-hour conversation with lots and lots of details. Can the victim and can the first complaint witness recount all of that, verbatim to the extent they remember it?
So there are a couple of limitations I'm thinking of. The first one I'm thinking of is the limitation that the first complaint witness can't testify to anything that the victim, him or herself, did not testify to. So if the complaint witness remembers the story better than the complainant, then we're not going to be able to hear that. And that's just the way it is. The other limitation I am thinking of...
In the next case, so you might want to hang around for that.
Sure. The other issue I'm thinking of, and now I'm worried whose ship I'm sinking by answering this now that you've said that, is there's always the discretionary question of, what is the bounds of the communication? I'm thinking of Stuckage. Am I saying that wrong? Anyway. But that one, where it was shortly after King and the Commonwealth tried to introduce this package that it considered one communication. It was a letter and then a follow-up conversation, and then I showed her a diary entry to corroborate it. And it turned into a whole package, and they were thinking of that as a single communication. But judges have to decide the beginning and the ending, the framing, what is a communication versus multiple complaints. I will let you get on with your day. Thank you very much.
Thank you.
Thank you. Thank you both. All right, our third case, and we do expect to take a break after this one, is number 25P1540, Commonwealth versus CORY ALVAREZ.
Good morning to the justices of this honorable court. Brian Kelly on behalf of CORY ALVAREZ. Mr. ALVAREZ is challenging the single indictment conviction of rape of a child that occurred in the Plymouth Superior Court over the summer. We advanced multiple preserved errors, the most paramount of which is the narrative form of which the SANE nurse was able to testify as to an account that was given to her during a so-called SANE interview at a hospital later that night. In addition, we're suggesting to the court and advancing to the court that the Form 2A box that was checked for the purposes of penetration, those two statements admitted over objection by defense counsel cannot be used for the substantive purpose of finding that element of penetration. As the court well knows, in this particular case, the young lady who testified did not testify in the defense's view to any element, or excuse me, any fact that could derive that particular element of penetration. The testimony of the young lady distilled really down to its essential facts, and the light most favorable to the Commonwealth is that young lady was in the room, my client, there was some contact. She gestured to her neckline. When asked after that, was there any other contact to any other part of your body, she said no. She later said in that examination over objection that her clothes were off and my client was touching her or on top of her. From my memory of the testimony, there was no evidence advanced that my client had his clothes off. Factually, as the court knows, the question then becomes whether that contact, at that moment in time after the young lady testified, defense moved for a required finding, forecasting for the court that there was DNA evidence, of course, that was going to be...
Well, she also said, he raped me, right?
Right, to which we objected, and there was a contemporaneous instruction by the court that that word would not be, it's a sort of legal term, and the instruction in the final instructions, Your Honor, were that that particular word cannot be used, I'm paraphrasing, but that particular word cannot be used as a substitute for the more detailed question of penetration itself. So that sort of dovetails into the first complaint analysis, which the court, I think, is forecasted here a little bit, but if I may, ultimately, this really breaks down to five.
I'm not so sure. I mean, as I read the instruction, I thought the judge was saying that the Commonwealth still has to prove the elements of the crime.
Right.
So it wasn't, the judge wasn't saying that her testimony was not relevant or can't be considered. It's just saying, you have to consider the elements of the crime. So if you have jurors who are satisfied with the demeanor of the witness and so forth, and she says, he raped me, that guy right there, they can certainly consider that.
My memory of it, Your Honor, was that the objection was sustained. And I continue to object to the word rape because of the issue that we're dealing with right here, which is without a more detailed instruction, the jury would be left to infer that that's, in fact, what happened. And as the court well knows, this is a person who's not from the United States.
All right, so what you're saying, if I understand it correctly, is you're saying that a jury cannot give any weight to the testimony of a female who says, I was raped.
I don't think that's the correct way I would say it, Your Honor. It cannot be used as a substitute for the more detailed testimony of penetration, because that word rape, especially coming from a person who's not from the United States, could take on multiple different contexts. Could be a word that is a different word to them, could be a different context, could be a touching that is only up here, could be a lot of things. And I think that's why the cases suggest that that word alone should not be used as a substitute for the more.
I haven't seen that in the case law. What case says that?
Which case says that the word rape cannot be used?
Yeah.
Okay, if I may have a moment.
That would be kind of startling. I mean, it just seems to me that a female should be able to take the stand and say, I was raped by that guy sitting right over there. And if that's all she's going to say, well, that's fine. Then it's up to the jury to weigh that. But I don't think we can say that no weight should be given to that at all.
Well, I'm not sure that the word weight is the word I would use, Your Honor. The word, the fact that the court sustained the objection, I think, is important here, because I think even the court at the time agreed that that word could not be used as a more substantive question about whether or not that's sufficient proof. So in other words, I think she's got to testify exactly what happened, because that word rape, as I understand it, and I think the judge agreed with me at the time, by sustaining the objection, was not a sufficient substitute for the. It doesn't mean that the word, I suppose it doesn't mean that they can't consider it, but they can't consider it for the proof of penetration, is what I think the court even found during that objection.
Well, that's what I'm finding puzzling. So if a woman says that I have been raped, a jury cannot consider that as proof of penetration of her body. That's what you're saying?
Yes.
Oh, okay.
And I think the court, even at that moment in time, I think the Superior Court judge had agreed with me that that's not sufficient testimony without a further detailed testimony. And I think that obviously my concern here is that given the fact that she's not from the United States and she's testifying through an interpreter, which if you go through the transcript, you can see there's some issues with respect to the interpretation. That word can take on a different context in a different country. So I think that's also part of the concern here. But that more detailed, even during the instruction at the end, the Superior Court instructed the jury that they couldn't consider that word for its substantive purpose of penetration.
So what is your argument with respect to the finding of the DNA swabs taken from the external genitals? Why isn't that enough to put the Commonwealth over the sufficiency line?
For required finding?
For a finding of penetration, right?
So there's two issues there. One is there's one particular swab taken. Right? So from the testimony we heard, the external genital swab is somewhat internal and somewhat external. There's one swab. It's not two swabs. Yeah. So even if the court were to say, okay, that's enough, we don't know where that DNA came from. We don't know whether it was, where exactly it came from in terms of that particular DNA. And of course, what complicates this issue even further is the testimony received about this being potentially semen, which we made an objection over objection over objection with respect to the misleading characterization of these being semen when there was no confirmatory test for semen. So the jury is left with this impression, which is paramount in this particular case. Just to go back to the first question, which is, she goes into this room, she makes this claim. There's no, when you look at the SANE documents themselves, most of her claims were not supported in terms of the bleeding, and there was no redness, no abrasions, no anything like that. So The question then becomes, again, distilling this down to just the statements, and I believe that that word rape should be set aside. I think that should not be considered by this court in terms of penetration, because it was sustained and because the jury was told at the end. So going back to this question about the touching, how does that DNA get there? How do we know how that DNA got there? So we know that from the testimony, from even the government's witnesses, that the transference is possible and even likely in some scenarios. We know that they were in the room together. We know they were touching the tablet together. We know that transference is possible. What type of DNA was that? They want the jury to believe it was semen. We have no evidence it was semen, other than them suggesting the name of this.
These are all good arguments for the jury, but I wonder, does it just go to the weight of the evidence versus whether or not there's a sufficient ground for a jury to find penetration, given these? I mean, that's the critical question. I take your point. We don't know exactly where the swab came from. We don't know exactly what kind of DNA it was. We don't know how it was transferred there. Those are all good arguments to the jury, but for our perspective, sufficiency is a very difficult standard to win on appeal. And I guess that's why I just don't understand. How do we kind of like look at that evidence and say, yeah, there wasn't enough here?
So I take the court's argument to mean that cobbling together some of these facts, which is they're in the room together, there's some contact, we know that. She even taking her statement, she states there's some contact. And then setting aside all the other issues with the first complaint and the DNA and all of that, is it sufficient if you cobble that information together with the DNA? So here's the problem I have with that. There's a number of cases, Commonwealth versus Mamey, 407-412, which is a 1990 case. And of course, Roby, which we've also cited, which the SJC has said that even when there's a touching, in Mamey, there was insufficient evidence of penetration for the complainants who described pelvic rubbing, breast contact, clitoral touching, and excuse me for this kind of language, but I think it's important to get into the details here. So how do we know how that DNA got to the location it was? And given the fact that there was only one swab used, how do we know exactly where that DNA was? Now, the government might say, well, in the light most favorable to the Commonwealth, you can say it was in the most inner portion of it, but there was no internal swab you might see from the transcript. The internal swab did not find semen. The external swab did not find semen. It's just DNA, Your Honor. And so I find no case that supports this contention, that these two things are enough, that the word rape, let's say, plus DNA equals sufficient evidence.
So can we just focus on the sane nurse's testimony for a moment, and her testimony that the victim told her there was penile vaginal penetration?
Yes.
Are you saying that that question, which I guess is on the same form, which we don't have in evidence, do we? I mean, we don't have in the record appendix, at least, that I can find. But
if it should have came up, I would have thought it would have come up for the record from the Superior Court.
What we get is the docket entries, and that's really it. We don't get any exhibits. So,
okay.
But are you saying that that question on the form is per se intended to elicit testimony for use in a prosecution?
Yes.
Rather than to be used in medical diagnosis and treatment?
Yes.
So you're saying that answer to that question should never be admitted in a sexual assault case?
I believe the name of the case is Jones, which is a SJC case that talks about these types of exchanges being for the purpose of prosecution and therefore not medical questions. So I can see where the court is going in the sense that maybe we could split this down the middle and say, well, maybe some of these questions are for medical diagnosis, maybe they're not. But the bottom line is that this is a person who works for the government. She works for the Department of Health and Human Services. She's not just there to do medical diagnosis or, excuse me, treatment, okay? She is there to collect evidence for a prosecution. It's clear. And the one thing about transcripts that don't give the court really a sense of how this testimony was, she was on the government's side. She testified on behalf of the government. She put in statements that I thought were wholly inadmissible over the objection of the defendant. We continually objected to these statements. It was, honestly, just statement after statement over our objection, over our repeated objection. I understand Dargan does typically permit these kinds of boxes to come in. But to my knowledge, there's no case that permits this kind of testimony without the witness first saying something close to penetration occurred. There are cases that talk about fellatio, touching on the penis, where there are young children involved. That doesn't come close to this, Your Honors. This does not come close. I think the battleground here, honestly, is whether it's a new trial or this should be set aside. And we are arguing forcefully that it should be set aside because Mr. Alvarez can never be put back in the same spot that he was. All of this testimony that was received, all of this objectionable hearsay, DNA evidence that was not supported in violation of Daubert, Lanigan Standard, the testimony of the first complaint, the objections during the closing, Mr. Alvarez can never be put back in the same spot. Never. If you order a new trial, they will just clean this up and fix it. And that's why I think this should be set aside. That's why I think the convictions in this particular case should be set aside. To the court's point, I think that I'm running out of time. I can send the court a letter. I know it's permissible. I know there's a case, and I believe I cited it in my motion to stay, which the court may have, that says that the word rape is not sufficient for a conviction on the question of penetration. I'm happy to send it to the court.
Yeah, if you have that case, please do send it in.
Thank you.
Thank you. All right, we'll hear from the Commonwealth.
May it please the court, Carolyn Burbine for the Commonwealth. I would like to disagree with my brother insofar as the judge sustaining the objection to the word rape. The judge rather recognized that rape was what the victim testified to, and he did not want to try to put words in her mouth as to what she should describe as a witness, but he did say that he would technically recognize that there's also a legal definition, and that's the position he took. He didn't strike the victim's use of the word rape. And indeed, Sherman states rape is not just a technical term. It is also widely known as a layman's term, and that the common meaning of rape in a sexual conduct context implies sexual intercourse. And as a result, the victim's testimony that established each essential element of the crime should be deemed sufficient alone here as enough.
Are you reading from a case? I missed something.
No, Sherman was the case I was referring to when I was reading that rape is not just a technical term, and then I launched into my take on our evidence.
Certainly the rule isn't that when a victim says he or she was raped, that's not probative to the point. But I think we have to look at the context of what exactly she testified to and what she did say and what she didn't say and make a judgment. Does all that collectively establish an issue of sufficiency, right? And here
Yes.
she's saying,
Yes.
you know, do you know what part of your body he touched, you know, and she points to her chest and there's no kind of like details that would sort of suggest that the conclusory term rape necessarily meant rape in the sense of
I'm asking the court to consider it in the context of everything that she said.
Okay.
Not just,
Well, what else did she, I mean,
What
just,
else
just
did she-
isolating her testimony, and I know
Yes.
there's other evidence here, and I don't want to belittle that.
No,
but
I understand
What
that.
else that she said gives us confidence that when she said rape, she actually meant rape in the sense of how it's defined in the
right.
statute?
So I would point to the fact that she said something bad happened in the defendant's. Before that, he had said that he wanted to rape me. I said no. He said to go to his room. I said, no, we went to his room. And then, and there's no question she had difficulty. But taking that into account, that she couldn't identify parts of her body. But I would note the judge did make a finding that there seemed to be some issue with this victim and her ability to communicate. So beyond that, something bad happened in the defendant's room. He raped me. She also said he removed her clothes. She was on the bed. His body was on top of her body. She felt his body on top of her body. And I think when you take all of that together with he raped me, and that rape can be a layman's term for sexual intercourse, which ordinarily is vaginal penile penetration, we had sufficient evidence just from her testimony alone. And we have the case Gonzalez-Santos that says that if a victim's testimony is sufficient and credible, it can establish all of the elements of all the essential elements of the crime. And I feel that we did do that here. It's a close call, but I feel that we met it, especially when we're looking at the evidence in the light most favorable to the Commonwealth on a motion for required finding. That's the standard that we're looking at. We're not at the beyond a reasonable doubt stage. We're looking at light most favorable to the Commonwealth, and I believe that with this testimony, we met that standard. But we also didn't just have her testimony. We had the same nurse's testimony. We had the DNA testimony. I think when you take all of that in combination, we definitely made it over the rail to sustain a claim of an error in the judge's ruling on the motion for required
So
finding.
is Mr. Kelly correct that it was one swab that was kind of all over the place on the external?
No, actually
or was there more than one swab taken? I couldn't.
The same nurse described it as, she described how she does this swabbing, and then she talked directly about how it was done with the victim, and she said she did it as the protocol says. And she takes 2 swabs at the same time, puts them in sterile water, I believe it was. And then she explained, using the diagram, how she moves the swab from each area. And the diagram showed areas such as the labia, the vulva, the clitoris, all of those areas, which Donlin and other cases tell us are the intimate areas, which if a defendant's penis touches that area, it's sufficient, it's contact, however slight.
Not to get too graphic, but was there evidence that the swab exclusively went in those areas and not also in a part of the body that would not necessarily indicate penetration?
Yes, I would say that if you read her testimony very carefully and you look at the diagram, we put that copy of that in our brief, you will see that these are the intimate areas of the body, that the names of the areas that she described are the ones that the case law say touching, however slight, is sufficient to prove penetration. And I think with that evidence, I think it was actually very compelling, her testimony, and I'd urge the court to read it and look at that diagram. It's in our facts section. It was marked for identification as B, and we printed it right in the brief in the facts section.
So where she uses the word rape in her testimony and the father says, she told me that he had sex with her, does that go beyond the permissible bounds of first complaint testimony?
I don't believe so, especially when you look at Sherman, and Sherman says that is a common layman's term. So I think that I don't think it goes outside. I believe it's.
But does sex mean something different than rape? Is it broader?
I think, well, first of all, I don't think the case law requires that it match perfectly. I mean, you have 2 people testifying, giving their own versions of a story, and I just don't think that you have to have it be completely matching. And indeed, maybe it's a little suspicious if it does. And in fact, it does help the defendant if it's not consistent, in that he can use it on cross-examination and in a closing argument to point out inconsistencies in between the victim's account of the first complaint to the father and the father's account of it. Now, I understand that it can't be so incredibly inconsistent. That is a problem. But I feel that layman's term sex and rape.
So if the victim had never used the term rape, and the testimony had just been, he had sex with me, whether it was her direct testimony or the father's first complaint, would that have been sufficient to establish penetration?
Alone, well, I mean, we can't use the first complaint anyway substantively.
Right.
So
If
I
she
don't
had
think we have
said,
that.
rather than using the term rape, had used the term sex, he had
And then
sex with me.
And the father said sex, then they're consistent. So, I
Right,
mean.
but would sex, I mean, you've said that the term rape is commonly understood as meaning penetration, and
I'm sorry, it's commonly, well, it's meant for sexual intercourse,
sexual
which is
intercourse.
vaginal penile.
Okay, right. So what about the term sex?
I think it's sexual intercourse, sex, I don't think you get a flavor of unnatural sexual intercourse or of anything. I would say it's consistent. In my view, it would be penile-vaginal sex as well. I don't see it as inconsistent. And then we have the chart in our brief where we showed and I just don't see anything really inconsistent. I think that perhaps the closest one would be the sucked on her breast comment. That's slightly inconsistent, but she did point to her chest area, and she did.
As you point out, though, that it doesn't have to line up perfectly.
Right.
Right.
That's right, Your Honor. And I think it's just makes sense that when you have two people telling a story individually, you're not always going to get the matchy-matchy language, and it's not required. The case law doesn't require it.
What case gives what you would say the most latitude in terms of additional details from the first complaint witness that were not related by the victim?
I think I'd say King and Rivera. They both say that first complaint testimony does not have to replicate precisely a victim's testimony. I think those are probably the best for us. But I mean, it's a general concept. I really don't think that we have.
But just to be clear, the father's statement is corroborative. It's not independently. We don't look to that independently to determine the sufficiency analysis, right?
Right. I mean, this is just limited to her credibility.
Yeah.
I mean, we're using it
We're
purely.
not, but again, on sufficiency, we're not really assessing credibility. It's it's assumed credible, right? So I'm not sure it really moves us beyond what she said herself.
No, yes. I mean, it's what she says, not what he said. Yes. I'm not sure what the court would like.
Can you shed any light on what the ADA meant in the closing when talking about the permissible use of the father's testimony? It was pretty murky to me after several readings.
I'm not sure I agree that it was murky. I think if you look at the first sentence of that section of the closing, and keep in mind the judge's instructions before the father testified about first complaint, he gave them the instruction. And then the prosecutor, she started that passage, and the defendant's brief doesn't reflect this. We did try to make it prominent in ours. She starts that passage with, quote, "Now, in considering the victim's testimony, you can also consider what she told her father on that day of the incident." And to me, she's telling the jury that when you're assessing her credibility, considering her testimony, i.e., assessing her credibility, you can consider what she told her father on the day of the incident.
It's the IE part that I guess is kind of.
I mean,
what
it's.
she says is you can consider what the father said.
But as she.
Consider the facts here and what happened on that day, which kind of suggests.
But I think when you.
Considering it for the truth.
I don't agree. I think that when you read the entire passage in its entirety, you see that what she's trying to talk about is credibility. And then after that, she runs through the evidence, the substantive evidence, and doesn't include the first complaint testimony. So I don't think that, I think that the jury having received that prior instruction before the father even testified, and the father's testimony pretty much consisted of the first complaint testimony. There wasn't a lot of other testimony. I think that the jury would have understood, oh, this is what the judge was talking about. Oh, now, when I consider her testimony, I mean, it's not perfect, but I don't think the jury could have misunderstood it, given the fact that they also got the first complaint instruction again in the final instruction. So I think when you look at the statement in the context of the entire closing, the evidence that was presented, the final instructions, the jury would not have misunderstood this to the defendant's prejudice. I'm trying to think of the right word. Did the court have any further questions?
I don't think so.
Thank you very much.
Thank you both for your arguments. Interesting case. We will take our 15-minute break now, and we'll be back to hear the other three cases. All rise.
Please, court will stand in recess.
All right. Our fourth case will be number 25P845, Department of Children and Families versus Mother and Another. And I would just remind the parties that this is an impounded case, so no identifying information. Oh, I'm sorry, I should have established. How are the appellees splitting time, 9 and 6?
9 and 6, Your Honor.
Okay, thank you.
Members of the panel, may it please the court, Nicole Paquin on behalf of the appellant Mother who is watching online today. Mother asks this panel to vacate the juvenile court's decree finding her unfit and terminating her parental rights. There are two issues that I'd like to address today. The first is, if a parent cannot explain how a baby's injury occurred, is there a path towards reunification? It is abundantly clear from the judge's findings that the judge's decision to terminate Mother's parental rights relied heavily upon Mother's inability to explain the baby's injuries, mainly the skull fractures. The judge made significant findings that the central issue before the court remained Mother's lack of explanation, that was the central concern, that was the paramount concern. Regardless of whether the department meant that its action plan task for the mother to be open and honest with the department was to be construed as requiring an explanation, which DCF in their brief argues that's not what they were requiring. Regardless of what DCF actually required, the judge at trial found that the action plan task for Mother to be open and honest was specifically added because Mother could not provide an explanation, and that's in the second page of the findings, addendum page 58 to Mother's brief, and that neither parent took responsibility for or offered a reasonable explanation as to how these injuries occurred, and that's in conclusion of law 36. The judge's determination of unfitness on this basis, because Mother could not provide an explanation, is erroneous under adoption of Iris and under adoption of Yelena. And I'd like to go through these two cases because Iris and Yelena put forth several factors that should be considered in a situation such as this. Iris related to an unexplained head injury in a 1-month-old, quite similar to the case that we have here. And in Iris, the first factor that was considered was whether the parents had exclusive custody. Here, the judge made 3 findings which are clearly erroneous, that the parents had the exclusive custody of the children. In finding of fact 135, the judge found that Mother testified that either she or father were always with the children. And in making that finding, the judge specifically cites to Mother's testimony of June 21st. And then goes on to say that the judge credited Mother's testimony. But Mother's testimony was not that Mother and father were always with the children. She testified first on June 21st that after the family returned home from the hospital for hospitalization to RSV, that the caretakers were mother, father, or their grandmother. Also on June 21st, she was asked, did Mother and father ever go out and leave the children alone with another caretaker? And Mother testified, yes, we left them with either my mother, the maternal grandmother, occasionally the maternal grandfather.
So I understand the point you're making based on that passage of the mother's testimony, but at transcript 597, 598, the mother says, the counsel asks, even if you were having a depressive episode and needed time for yourself, the father would have been with the children. Is that fair to say? And the mom says, sure.
And the questions leading up to that, either on 596 or on to 597, she's asked about when you returned home from the hospital with RSV. So that question was fairly specific in time. When you returned home, who was the caretaker. And then she's asked clarifying questions later that same day on page 651. Did mother and father ever go out and leave the children alone with another caretaker? Yes. And we have the maternal grandmother's testimony that she was there every other weekend. And that's transcripts pages 371, 387. And so we have here a situation where mother was not the exclusive caregiver. Father had stepped up and was providing more care than mother was, because mother was suffering from these depressive episodes. She testified that she was often crying, she was often sleeping. So this could easily have happened when mother was not in the room, when she was out of the home, when she was asleep. Mother was not the exclusive caregiver, and the judge repeatedly relies on mother's own testimony. So if the judge found mother credible, mother testified that she and father were not the only caregivers. There were all of these grandparents involved as well. So finding of fact 135, 156, and conclusion of law 24 are clearly erroneous based on mother's testimony, which is what the judge purported to rely on. The next factor under adoption of iris is whether any individual was an inappropriate caretaker. There's no evidence in the record that the grandparents, which were trusted with the children, were in any way unfit. Mother and father had successfully raised a toddler who was 16 months old at the time of removal. Mother had no reason to believe that father was unable to parent the baby, just as they had co-parented, co-raised the toddler. Notably, at the time of removal, finding of fact 92 and 95, there were no marks or bruises on the toddler. The toddler's skeletal scan was negative. No injuries were ever found on the toddler. The next factor was whether there's evidence sufficient to establish that the parents knew who caused the injury or when it happened. And here we have a time period, according to Dr. Sell, the expert, any time 6 weeks prior to the emergency room visit, which occurred on October 9th. So any time 6 weeks prior, at any of these weekends when all these grandparents were involved, this injury could have happened. We just don't know. The next factor is how much force would be required to cause a skull fracture. Dr. Sell, again the expert, testified that this is consistent with one single impact or fall, including a fall onto a carpeted surface or from an unstable surface, and that's testimony pages 83, 101, and 103. Whether, the next factor is whether it's an injury or accidental or abuse. And here, the judge determines that it's abuse, but Dr. Sell very clearly testifies that it could be either. The only reason why he finds it highly concerning for abuse is because no one can explain how this happened, which sort of brings us back to the first factor. But Dr. Sell was very clear that it could have been accidental or non-accidental, that's transcripts page 95, that these types of fractures are actually a common thing. They see them 4 to 5 times a month, transcript 99, because babies have a big head and they tend to fall head first. These things happen, testimony, transcript page 102. And so where the evidence is equivocal, that it could be an accident or it could be abuse, the fact that mother cannot provide an explanation does not tip the scales in her favor.
I totally take your point about the similarities between this case and adoption of Elena with respect to the skull fractures. I guess I'd like you to speak to the bruising issues, though, right? So the judge found the mother's testimony regarding whether she observed the younger child's bruising to be inconsistent, not credible. She said the judge didn't credit the mother's statement, said she didn't see the bruises when she was bathing and feeding and changing younger child at home. So accepting that finding, does that sort of change the balance when it comes to what the court said in Yelena about, how do you resolve these kind of undetermined issues?
No, I don't believe so for a few reasons. First of all, the mother could not recall when she bathed the child. She was consistent in her testimony that she never saw the bruises before that day that she brought the child to the pediatrician and then to the ER. But her testimony did change regarding when she changed the baby and when she bathed the baby. And considering these were events that she did nearly every day, but occurred 3 years prior to when she testified, I think it's understandable that mother might not remember if she bathed her baby that morning or the previous morning. But she was consistent that she never saw the bruises. And then there's no testimony, none whatsoever. Dr. Sell never testified to the issue of how old the bruises are. Right, so the department raises some arguments about about the age of the bruises, but there is no evidence at all about how old the bruises are. So we don't know if the bruises occurred for the first time on October 9th. There's nothing to support that they were there earlier. Also, Dr. Sell, Dr. Sell was never asked this, about this specifically, but there are entries in the medical records themselves where the review of systems, the providers listed hematological, bruises/bleeds easily. And that notation comes up 4 times in the record. So it's unclear whether when the bruises occurred or
I mean, you're essentially asking us to kind of reject the judge's credibility finding as to the bruises, right? I understand your argument that there may be reasons to do that, but you're essentially saying we should find that determination clearly erroneous?
I think you should, but even if you don't, I think here we have a mother who promptly obtained medical care. Right, so even if she was afraid to admit that she saw the bruises the day earlier, she promptly obtained medical care. She had brought this child to the pediatrician before. The children were medically up to date at the time of removal. She went back to the pediatrician asking for help for this colicky baby who would not stop crying on October 9th. And so even if the mother saw the bruise a day earlier, she didn't delay in obtaining medical care. She was actively asking for medical care for this baby. And it was only when the pediatrician finally said, essentially, there's nothing more we can do, take this baby to the ER, that's when she brings the baby to the ER. And that's how the rest of the story unfolds. And there, at the ER, a nurse specifically addressed father and said, do not burp the baby that way. I'm paraphrasing. Do not burp the baby that way. You could damage the baby. And so we have this knowledge in the record that father's burping the baby in a way that's too heavy-handed. Mother acknowledged that she was concerned about the way that father was burping the baby. She asked him not to do that. Maybe she did not intervene enough there.
Is there a test that she asked him? Because the judge said she did nothing to stop this from happening.
The judge made that ultimate finding, but there is testimony that father could be a bit heavy-handed, but the baby didn't cry or scream when being burped. There is, I can't seem to find that citation. I know it's in my brief. I can certainly supplement later with a letter if you'd like. But mother did testify that she had addressed that with the father, and also the grandmother testified that she had addressed it with the father, and the father's explanation to both was that he had been instructed to burp this baby this way because of the colic, and that's why he was doing it. And so this is absolutely a moment for educating these parents, not grounds for termination of parental rights.
Was there any medical evidence that the bruising was caused by something other than the father's method of burping the baby? I didn't see anything in Dr. Sell's testimony saying, oh, that's unlikely. He said, if that's what did it, that was an inappropriate amount of force, but he didn't say, no, this couldn't possibly have happened from, these bruises wouldn't have resulted from the father burping the baby in the way he describes.
That's correct, except the judge testified that, I'm sorry, not the judge, the expert testified that he was not given information about the manner in which father was burping the child. So there was never any demonstration. Dr. Sell was never allowed to speak to the parents, so he did not know how father was, what position the baby was in, how much force was being used. Dr. Sell did not have that information.
Yes, but, what concerns me here is, and looking at Dr. Sell's testimony on page 65, which was fully credited by the judge, by the way, he said he had multiplanar bruising, meaning bruises on multiple planes of his body. That is concerning. Why is that concerning, doctor? He is a pre-mobile infant, and he is under 6 months of age. Those infants don't typically bruise, even accidentally. So that's highly concerning for an inflicted injury and or physical abuse if there's no good history of an injury, trauma, or fall, or something to explain that. So what concerns me is that this isn't like a single event, that there was a terrible accident, nobody's fault, sometimes these things happen, but there's these bruises on multiple planes suggesting, coming from different directions, and they don't bruise easily. So there's some kind of trauma going on to this young child.
So as far as the bruising on multiple planes, because Dr. Sell did not have information about how the father was burping the baby, the father had testified how he did it. And in doing that, if you're holding the baby and patting the baby, you can, the father's testimony was that he could have bruised both the front and the back. The grandmother testified that at the hospital, the bruise looked like it could have been from a hand because of the way that the bruises were on the baby's body if you were holding.
But that's not consistent with the doctor's testimony. He said they don't bruise easily.
The doctor said that that babies do not bruise easily, and so if this happened from burping, it would have happened through an inappropriate amount of force. And no one contested that father used an inappropriate amount of force when burping the baby. But Dr. Sell just did not have information about what that force looked like, how heavily the father was burping the baby. Dr. Sell did testify that it would have been inappropriate. He did not testify that it could not happen through burping, just that it would have been inappropriate force, which is exactly what the nurse in the hospital saw father use and intervened at that point. Right? The nurse on October 9th said, "You're burping this baby too hard, you're going to damage him." I think damage is the word that she used. And so, yes, the judge credited Dr. Sell, but I think the explanations offered by the parents as to the bruising are consistent with Dr. Sell's testimony.
And mom didn't see the bruising?
The mother testified that she never saw the bruising until October 9th.
And what about Dr. Sell's testimony that basically refuted each of the mom's explanations for the possible injuries to the child? He said it's not possible.
Mother, even as she was offering these alternative explanations, consistently said, "I don't know how this happened," and then provided, there was this incident when my dog jumped on the baby. Maybe it happened then, but I don't think so, but maybe it did. This sort of presentation. That is the inevitable result of having the Department of Children and Families requiring her to come up with an explanation. She did not know how this happened, and the department kept telling her, if you don't explain this, you're not going to be able to reunify with your children. And so this is exactly what Yelena warned us about, right? If you require a parent to come up with an explanation, they're going to grasp at straws and try to provide any sort of explanation. Mother also had asked the department to be able to talk to a provider to better understand the mechanism of injury, how this might have happened, so then she might be able to figure out how it did happen. And the department originally considered that and then ultimately did not allow her to speak to anyone. So this is a mother without any medical training, a lay person, trying desperately to understand how this happened and coming up with theories that, no, they did not explain the injuries. but she was doing her best to satisfy the department's requirement that she provide an explanation when she did not have that information.
Okay, we'll have to leave it there. Thank you.
Thank you.
And we recognize we've got we'll add a couple minutes on. Why don't we add, if possible, 11 minutes to the, make 11 minutes for the department, and I guess it would be 8 for the, yeah, 2 extra minutes. Okay.
Thank you, Thank you, Your Honors. Judge Sachs, before I begin, can you let me know when I'm getting close to a minute or two?
Yes, will do.
Thank you.
Yeah, happy to.
Good morning, William Cuddle for the Department of Children and Families. The department's asking this court to affirm the trial court's decision terminating mother's rights. The court also terminated father's rights, but that's not before you today. I've heard mother's argument in the brief. I want to just make a couple of points. I know you've read our brief and are familiar with the record. The court did not just decide to terminate mother's rights because mother couldn't give a reasonable explanation about how the child got injured, and clearly the child was injured. The court also was significantly concerned about mother's lack of insight and understanding the severity of the injuries to this child. And also, the mother didn't benefit from the services related to her anger, specifically her emotional stability. Those factors taken together put the court in a situation where the court could not say, based on all the evidence that she heard and all the credible expert testimony from Dr. Sell that came in, that all the parties agreed to, could testify, that she could return this child to this mother.
It's pretty clear to me that the skull fractures were the most significant factor, and the mother's inability to explain it. So yes, the judge did talk about some of these other issues, but it's, you know, speaking only for myself, that was the predominant factor, and at least that's where I think the biggest gap between the parties is. So I would like to ask, that Dr. Sell says the injuries were most consistent with child abuse in the absence of any history to explain it, meaning in the absence of any evidence about an accidental occurrence.
This was a pre-mobile infant. Yes.
Right.
Yes.
But isn't it just as logical to say this is most consistent with an accident in the absence of any history of child abuse to explain it? What tips the balance toward this being the result, the skull fracture in particular, being the result of an intentional injury or abusive conduct versus an accident?
Well, the court found, and based on Dr. Sell's testimony, the doctor said several times, and it's what the court put in her findings, that absent an accident or some other explanation, this is what happened. And that's the only conclusion the judge could come to. He couldn't speculate as to, well, maybe the child fell. And I would respectfully disagree with you, Judge Sachs, in terms of, I clearly agree with you that the skull fractures were a significant issue, but so weren't the bruises. And the bruises were significant for many reasons.
But no one disagreed with, Dr. Sell never disagreed with the explanation that the father was using inappropriate excessive force to burp the baby. Is that accurate?
I don't know when the father testified versus when the doctor testified, to be honest with you. I do know that the doctor testified that if the father, in fact,
it would be inappropriate.
Burped the baby as he did, it would have been inappropriate. Because babies don't bruise like that.
Right, but that was not those weren't unexplained injuries, were they? At least most of the bruising was not unexplained.
Yes, they were. The judge didn't necessarily take whole cloth that father was there was a bruise on the child's leg that was unexplained. There's bruises on the back. Correct me if I'm wrong.
So given the father's explanation, the mother's explanation, the acknowledgement of the force used in bruising, what would tip the balance toward the judge finding that that was an unexplained accident that contributed to the inference that the skull fracture was
There were unexplained
Intentional.
injuries, Your Honor. Both were unexplained injuries, and there were significant injuries according to Dr. Sell. And what the department asked the parents to do and what the court was looking at, and this is far different than the Ulina case, and I'll get into that in a second. The court and was not looking at this case, and the department was not asking the parents to admit that they did something wrong. The parents were asked to explain what possibly could have happened, and they didn't do that.
Right,
And,
so the
and that goes to
department-
the credibility of the mother because
So DCF decides that mom wasn't open and honest. That, right? DCF said mom...
wasn't open and honest about, and to help understand
Yes,
how the
right.
child was injured.
Which means DCF knows that there's something that mother knows but isn't telling.
Not necessarily.
Well, then how can DCF say she isn't being open and honest unless DCF knows
I mean,
that there's
well,
something
let me-
in
let
her
me-
mind that she's not saying?
Let me back up. Let me correct myself. I think you're right that the department and the court were concerned that mother may have explanations that she wasn't giving, but not that she necessarily was the one who injured the child. That's what I was trying to say.
So how does DCF know that mother has an explanation that she's not giving?
If she doesn't, that's a great question, and I've been thinking about that and preparing for today. And you know what, Your Honor? That would not be a dispositive factor. If mother had said to the court, to the department and testified, I just don't know how it happened, okay? That's where the other factors that the court
She didn't
took into
say that? She didn't, I thought she said that many times. I don't
she
know.
gave- she
I
gave-
don't know how
she-
these fractures happen. Maybe it this way, maybe it this way. I don't know.
She gave all these improbable
But
examples.
that's because the department is saying you need to give us an explanation, right?
Right.
What
That-
if she legitimately does not have an explanation for the skull fractures? What is she supposed to do? The department says you need to give us an explanation, and she tries to, and then the department says that's not plausible.
That's
right?
where- you're
But
right.
But you're making, I think Justice Sachs' point is you're assuming that she does not have a legitimate explanation, and therefore the onus is on her to somehow justify it. It's
Well, you know what?
I don't want to use the word Kafkaesque, but it's a little troubling that she's asked to explain something and the possibility that she legitimately does not know is not accepted as a possibility.
If that was the end of the inquiry, I would agree with you 100%. But that's not the end of the inquiry. And that's why the department asked the mother to participate in services, and that's why the court found that mother did not have the insight to understand the severity of the injuries to her child. So say, for instance, that both of you are correct, that mother was put in a precarious situation, right? She knew something, but she didn't say, so what's she supposed to do? What she's supposed to do is explain to the department, through all of her time working with them, that I don't know what happened, but I know it was very serious. I want to try to figure out how this cannot happen again, and I'm going to participate in my services and work on my anger management.
Oh, it's
and my
because the
emotional
mother
stability.
didn't-
And she didn't.
It's because the mother didn't say those words, as far as we know, that she didn't take
No.
responsibility, as you're saying?
No, it's not the words, it's the findings that the court made about mother's.
Well, did mother
about her not giving a reasonable explanation or
Did
explaining.
mother
what
say
happened.
anything to minimize the seriousness of the skull fractures?
Say that again?
Did mother say anything to minimize the seriousness of the skull fractures?
Yes. Well, she said she said, and the court found, and it's in I don't know exactly where it is, Your Honor. It's in the record that we lost custody of our children over a disagreement about a boo-boo. That a child got a boo-boo, and that's in quotes. This child didn't get a boo-boo. This child had skull fractures and bruises on the front and back of his abdomen and on his side. Those aren't boo-boos. So yes, she did minimize that there. But clearly, in these type of cases where it's not certain, this is a lot like the Lorna case, which we cite in our brief, mother had the opportunity to work on her issues, and she didn't. She worked on some of them, and the court found that. Court was fair in assessing what she had done and what she hadn't done. But she still was having trouble with her anger management.
Her record on services was mixed.
Say that again?
Her record on services was mixed. It wasn't a complete refusal to engage in services. But she didn't do everything that was expected of her, right? But I guess if you take out the skull,
Respectfully,
can I
Your
just
Honor.
finish my question? Like, I'm just trying to sort of, if you take out the skull fracture issue.
Yes.
Is the finding of her failure to fully complete services sufficient to kind of justify termination?
It's part of the process. I didn't
Mr.
mean to-
Cuddle, I need to say a minute and a half to go.
I didn't mean to interrupt you. I apologize for that. I don't think it's insignificant when mother participates in an anger management class and then in the same year gets arrested for assault of her ex-roommate. That's not insignificant.
I'm not saying insignificant, I'm saying sufficient to warrant termination.
I believe that taking all the factors that she did not give a reasonable explanation in addition to not standing alone. Clearly, I hope you don't think I'm saying that because I'm not, and our brief doesn't say that, and the findings don't say that. They say combination of not giving a reasonable explanation about how the injury took place or what the circumstances were, not showing or demonstrating that she understood the severity of the injuries, and not working on her shortcomings having to do with emotional instability and volatility, all led the court to find by clear and convincing evidence that mother was unfit.
So this seems like the examples or the evidence of unfitness was limited to a particular time, and these things would not be expected to repeat themselves as the children get older. Is that fair? I mean, is the mother, even if she were unfit at the time of trial, was she permanently unfit?
I don't know. I mean, I agree with you that the child could grow up and the same circumstances wouldn't exist. Is that what you're saying?
Yes.
Yes, but I agree with you about that. But mother's failure to address her issues and acknowledge what happened, that would have to be demonstrated to show that it's changed. And there isn't any of that change. And the child's in both children in a wonderful placement. And mother is going to have contact with it. It's the mother's mother, who's the adoptive parent in this case.
Okay.
And just
Thank you. We'll have to leave it there.
Okay, thank you very much.
Yep. Thank you. And if we can reset the clock to, I think I said 6 + 2 is 8. Thank you.
Good morning, Your Honors. May it please the Court, I'm Jennifer DeFeo. I represent the appellee children. We are asking that this Court affirm the decision of the lower court to terminate mother's rights. And we're seeking a clarification, however, of the post-adoption visitation.
Can I get something else clarified before we get into that? So originally, the children filed a motion for leave to file a late notice of appeal. That was denied, and I think the children initially filed a proposed brief that would have sought reversal.
Correct.
Now the children have filed a brief that supports affirmance. Is that because the substituted judgment has changed, or merely because the children were not allowed to appear as appellants rather than an appellee?
It's merely because they were not allowed to appear as appellants. Under the CPCS guidelines, I am representing them as appellees, which is why I would prefer to focus on the clarification that I'm seeking on the post-adoption
So do the
language.
CPCS guidelines mandate that if the children are appellees, they cannot do anything but argue for affirmance? Or that they, I see you're advocating for a change in the terms of the post-adoption visitation, but are the CPCS guidelines such that the position of the children is determined by whether they filed a notice of appeal in time?
That is my understanding. Can I quote from CPCS guidelines? I cannot. But I do know that I was appointed as the appellee counsel. I did ask if I could, on behalf of the children, be appellant, and it was denied. So as I stand here today, it is in my appointment as their appellee counsel.
Okay. I can just say that we have had cases before where children as appellees have nevertheless argued for vacating a decree, so something to discuss with CPCS. I don't know the guidelines either.
If I am allowed to argue that the termination...
I'd like to know what the children actually want, not what they're locked into because of these procedural wranglings. So
So the children do not feel as though their mother is unfit, and I do not believe that the judge's decision or DCF's findings are clear and convincing that mother was unfit. The children have a bond with mother. Mother has some limitations. She's not perfect, but there is no perfect parent, and she's not expected to be perfect. What we have is a woman who suffered severe postpartum depression to the point that she would lock herself in the bedroom and cry. And it is during this time of her severe postpartum depression that this young child was injured. Is it clear whether she did it, father did it, or someone else did it? No. And the reality is nobody may ever come forward and say what truly happened, and perhaps nobody truly knows what happened. What we do know is this young boy had significant injuries. But one of the things that must be noted is Dr. Sell himself found that the level of injury of this young boy's skull fractures may not have been apparent to anybody, because immediately or very close to the time it happened, the child may no longer have any pain associated with the injury. There may have been a bump on the child's head, but the record reflects the child had a lot of hair, so a bump might have gone undetected. So if you take away the mother's hesitance to say somebody intentionally did this to my son, whether it was her or father, what do you really have left? Not a whole heck of a lot. And I think that there is not the clear and convincing evidence that there should be. I think this mother could have definitely used some further education. I think that there are some concerns as to her statements regarding marijuana use. And the law does state that unless there is a danger to the children from marijuana use, it cannot be the primary or sole reason to take a child from his mother. What else do we have? We have mental health issues. She worked very hard on her postpartum depression, and during the time that she had her postpartum depression, it was during COVID. She testified that she reached out for help. When she was able to actually get the help, she no longer had the issues with the postpartum depression. Yes, she still had depression, but she was working. She never had an issue with any of her visits. She was able to act appropriately with the children. She was able to care for the children during that time. She was able to meet their needs during the visits. There's a bonding expert that says these children are bonded with their mother. What else do we have? A criminal record. There was one incident in 2019 in which she was charged with a crime. It was dismissed. Yes, it has prognostic value, but years before, the children were removed. And then the one incident that happened in 2023, which mother claims was self-defense. She's in a very stressful situation. We don't know the outcome of that case because as of the time of trial, it had not been resolved. And even if she did get in a fist fight with somebody else, does that in and of itself show that she could not care for these children, that she would lose her patience, and that her anger management issues were so great that she could not maintain control? There's no clear and convincing evidence of that. So what else do we have? We have some mixed information about domestic violence in which mother and father had some verbal arguments which involved the police. There was one incident in which father, while intoxicated and highly agitated, stated mother punched him in the face. Never any restraining orders. Neither party was ever arrested for domestic violence during the course of the relationship. So while the judge may have lumped all of these together, what we consider a constellation of factors, it is very challenging to find that these incidents rise to that level. There is no doubt this little boy suffered something significant. But the reality is, during the time he suffered it, mother was not who she is today. She was suffering severely, and she acknowledged that. from day one. I was hiding in the bedroom. I couldn't eat. All I wanted to do was cry and sleep. There's nothing to show that had she not had postpartum depression, that this wouldn't have happened. And I think that the questions that we've heard is what makes this so much more likely to be abuse than an accident? And it could go either way. But where is the clear and convincing evidence that this mother presents a risk to these children? And on behalf of the children, they don't see it. And they are asking that the mother's rights be restored.
Thank you. Thank you all. Complicated case. All right. Our fifth case will be 25P662, Michael NWOZUZU versus Safety Insurance Company. And please correct me if I got the pronunciation wrong.
That was correct, Your Honor.
Okay, thank you.
May it please Your Honors, Godson Anosike for Michael NWOZUZU, the appellant in this matter. Your Honors, in addition to plaintiff's brief and reply brief, plaintiff argues that the trial judge in this matter made numerous errors in its rulings of law and findings of facts. Those errors, Your Honors, span all through this trial, beginning from the numerous motions in limine that were argued before the judge, through the jury trials and the bench trial regarding the findings of facts and rulings of law. From the word go, all parties agree that plaintiff was properly covered for all accidental damages in his policy. And then at some point, plaintiff reported a heat while packed. Heat while packed is covered in his policy. Undercarriage accident is covered in his policy. Accident while the car is in motion is also covered in his policy. Appraisal was raised, confirming damage to the front right impact area. The appraisal states that garage had 6 days to repair the damage. Your Honor, more than 6 days passed. Matter of fact, 18 days, the car was not returned. And on that 18th day, a supplemental appraisal was raised. With that, the insurer denied plaintiff's claims. In denying plaintiff claims, the insurer alleged that plaintiff did not provide it with sufficient facts regarding how the accident occurred. Meanwhile, it was a hit while packed. It was a hit and run. It was a side swap. Plaintiff did not have personal information of how the accident occurred. Plaintiff did not observe the accident when it occurred. How could he provide information regarding specific factual information regarding how the accident occurred. And the insurance stated that for that, plaintiff did not cooperate, and therefore they are denying the claims. Your Honor, case law on cooperation is that an insurer may not deny a claim based on duty to cooperate except there was a prejudice to it. And that's the law. Also, regarding the duty to defend, the court did not give any jury instruction on the duty to defend. The court...
Can I just back you up 1 second and ask, you said that the insurer cannot deny coverage based on failure to cooperate unless the insurer was prejudiced?
Yes.
And you're saying that the insurer was not prejudiced here?
Because, Your Honor, the car was properly insured and the policy covers any damages, whether it's hit while parked, undercarriage, or whether the car was in motion.
Does the possibility that the car was in motion raise the potential applicability of an exclusion or other reason why the coverage would not apply?
It does not, Your Honor, because it wasn't prejudiced. And the policy covers the accident even if it was in motion. My client did not have any reason not to report it. And also, Your Honor, from the moment this car was taken to the garage, the appraiser stated that the damage was from at the right impact area. That's what the appraiser says. And the appraiser, and including the insurer's phone log, internal document, states that the plaintiff's version of the story is consistent with their findings. That is to say that the plaintiff's version that the car was hit while parked is consistent with the inspection, the appraiser's inspection. And the appraiser also, in its supplemental appraisal, stated that garage did not seek authorization from neither the insurance nor the owner before it moved to completely replace practically all components of the front suspension. It did not seek the authority and did not get the authority of the owner or of the insurance company.
Can I just jump in with a question? So I think one of the things that the judge found in his decision, his 93A decision, was that safety presented evidence that the car was in motion when the accident occurred, and that the plaintiff, you, did not present any evidence to refute that. And the judge notes you didn't present, the plaintiff didn't contact the police regarding the accident. There was no police report filed. He never provided photos of the damage to the vehicle. He never, any evidence of the debris field around the vehicle, photos of the location. So there was no countervailing evidence provided by the plaintiff to rebut safety's case that the car was in motion. Do you disagree with that? Was there evidence presented that it was a hit and run?
Absolutely, Your Honor.
What was the evidence?
The evidence, actually, the burden is not on the plaintiff to investigate this matter. The burden is squarely on the insurance to investigate the matter.
Okay, so that's the burden. That's arguing about the burden. But did you present evidence establishing that this was a hit and run?
Yes, Your Honor.
What was that
including the
evidence?
fact that this car was inspected on August 22, 2017, and the appraiser's report confirms that from that inspection to the new supplemental damage, the car had been consistently under the possession, custody, and control of the garage. Meanwhile, the garage is authorized to test drive the car. And so whatever happened between the first inspection and the new supplemental inspection was between the garage. My client had no idea what happened. He didn't have possession, custody, and control of the vehicle between the two.
Sure, but if my car gets, hit and run, it's parked, it gets hit by another car, I probably would take some photos. I might call the police, have them do the report. I might present some evidence, showing what happened. And there wasn't any evidence presented by your client, as far as I understand.
Your Honor, the prevailing law is that an insurance may not decline to cover, and especially, Your Honor, this is an insurance case, and there is a special relationship between the insurer and the insured. And in this case, the Supreme Judicial Court created an important penalty against the insurer, where an insurer wrongfully refuses to defend. It has the burden of proving that the claim is excluded from the policy. It did not do it.
Well, I think the judge said your client made a claim and safety presented me with evidence showing that that claim was false. And therefore, based on that, it was adequate for safety to say the plaintiff is not complying with the investigation, and therefore it's okay for them to deny coverage. That's what the judge seemed to say.
Yeah,
so
but
what's wrong in that logic there?
What is wrong is that the judge ignored plaintiff's evidence, which was everywhere, including the report of the appraiser. The judge ignored all of those. And if I beg your indulgence to read the report of the appraiser in this case, Your Honor, because it will clarify most of what I'm saying. The appraiser in the supplemental appraisal stated, very visible damage to right front impact area, possible hidden damage once repair started, no prior unrelated damage. Shop requested supplement for additional parts, labor, procedures, and materials necessary to complete the repairs, copied to the owner and the shop. Note, the vehicle was inspected and written on 8/22/17. The shop decided not to contact us to request for supplemental inspection. Instead, the shop proceeded to replace practically every major component related to the front suspension. Based on my initial observation of damage, there were no signs that indicated that the front suspension sustained any significant damage at all. When I questioned the shop, I was told by the shop's appraiser that the damage to the vehicle was resulted from the vehicle running off the road, and it was warranted to replace all the items in question in order to manage to proceed with the repairs. Subsequently, I contacted the owner to further inquire about the nature of the original incident. During my conversation with the owner, I discovered that the vehicle was not even in motion when the damage supposedly occurred. The owner claimed that the vehicle was impacted while parked, side-swapped. The owner's account of the incident is consistent with my initial observation. Therefore, the type of damage to the front suspension that could occur to warrant this extensive repair or replacement of the major components was improbable. In fact, this would not have been physically possible while the car was parked.
Can you give me the records appendix site that you're looking at? What page is that?
It's, I believe, Appendix Volume 1, pages 43 to 55.
And what's the date of that?
Sorry?
What was the date of that report?
The date of the report? The date of this report is 9/12/17.
Okay. Thank you.
Your Honors, it is incredible that the judge requested and plaintiff provided jury instructions on all of those issues, including refusal to defend. The judge did not give the jury any instructions regarding refusal to defend. The judge did not present plaintiff's claim, cause of action number 5, to the jury. The jury did not return any verdict on the question of refusal to defend. It is incredible. And the judge, whereas here, Your Honors, the insurer denied the claims based on cooperation, the judge did not give the jury instructions on what insurer's cooperation requires. There was no jury instruction. Okay. The judge did
We're going to have to leave it there, so why don't you just wind up your sentence and...
Yeah, Your Honor, because of the numerous, the judge did not give jury instruction on everything, including failure to cooperate, which is, because of that, the jury returned adverse verdict on the plaintiff. The judge's instruction on contract, Your Honor, is not consistent with the prevailing law. Let me just touch that.
No, we need to leave it there. We've got your brief, and we understand the argument. So
thank you.
Thank you. The time is up. So. And we'll hear from the insurer.
Good morning, Your Honors. May it please the Court, Tom Francis for the Applee Safety Insurance Company. I'd like to go right to one of the central issues raised on appeal and developed in the appellant's reply brief, which is the subject of the jury instruction.
Let me just stop you there for 1 sec. Mr. Anosike, you may sit at counsel table during the argument. That's customary. So. Yeah. Thank you.
In my principal brief, I argued that the plaintiff failed to make objections to the jury instructions at the charge conference and after the jury instructions were given, except for one instruction involving Chapter 176D, which was explained that in a colloquy with the trial judge that the trial court was taking the Chapter 93A claim and reserving it, and it was not going to be decided by the jury. The plaintiff submitted jury instructions, and you'll find them in the 3rd volume of the record appendix. They are excerpts from secondary sources, and none of the instructions are tailored to the facts of this case. The appellant has argued that in his reply brief that there are several deficiencies with the jury instructions. The first one was on the burden of proof that the Judge Campo, the trial judge, placed on the plaintiff and stating essentially that it was the plaintiff's burden of proof to show compliance with the insurance contract. the appellant has argued that this was unfair and prejudicial because it forced him to prove that he was covered under the policy as part of his burden of proving breach of contract. In fact, there is case law precisely on point with respect to that particular aspect of the charge, and I refer the court to BOSE versus, believe it or not, Safety Insurance Company at 462 Mass 346, page 351, where it states that an insured bears the initial burden of proving that the claimed loss falls within the coverage of the insurance policy. So I would submit that the instructions which my brother claims and argues in his reply were inadequate as a matter of insurance law is just the opposite, that is completely in compliance with the precedent in the Commonwealth.
Can you speak just to a couple of the issues that your brother raised?
Could you speak up, please?
Yeah, I'm sorry, yes. Can you speak to a couple issues? Do you need to have a showing of prejudice on the failure to cooperate? Is that something that, to establish that, to not pay the claim because of the plaintiff's failure to, I guess the insured's failure to cooperate, that there has to be some prejudice suffered by the insurance company?
Yeah, I think that the case law does say that there is a requirement that there be some prejudice shown to the insurance company. Mm-hmm. And here, of course, there was.
What was the prejudice?
The prejudice is that when the insurance company is not given accurate information regarding the claim, its basic interest under the insurance contract is prejudice because it's unable to assess liability and exposure on the claim. That's particularly the case when all of the information essentially resides in the hands of one person. And so, yes.
But just to play that out a little bit in this case, so as I understand the plaintiff's argument, it's like, well, it doesn't really matter if I was a hit and run or the car was in motion. My policy covered both of those things. And I think Justice Sachs read, well, is there an exclusion that might have applied if the car was in motion? So is that the problem here, that we don't know if it was an accident when the car was in motion, that they might give rise to exclusions that wouldn't apply in the hit and run situation?
The policy requires a policyholder to give accurate information about the claim. That's what the duty to cooperate is all about, and that's what the case law states in terms of what the duty to cooperate means. It's not a question of quantity of information, it's a question of quality of information. Once that duty is breached by the insured, the insurance company is essentially at a point where it's looking at a breach of contract, and the claim that is being made, in this case it was a hit-while parked claim, loses its coverage because the evidence, as it was investigated post-accident, showed that the car was not hit while parked, that it was in motion when it was damaged.
Well, so I'm just trying to get at what difference does it make in terms of your ability to assess the claim? Right. So
is there a third party you would go after potentially?
Yeah. Or is there maybe the car was operated in a particularly dangerous manner that takes it outside the car? What? Just flesh out a little bit what the prejudice is from the fact that your evidence indicated that the plaintiff wasn't forthright about the car being in motion. What's the upshot for your coverage?
Well, the fact that the car was not hit while parked, at least that's the conclusion that was reached, puts the insurance company in a position of not knowing exactly what the claim was. And the question then becomes, how does it assess liability and damages for the claim that's being presented to it? So it has essentially lost its ability to make that assessment based upon the information given by the insured.
It seems to be a no prejudice standard, unfortunately. I don't quite.
I'm not.
Well, I mean, if you were to say, and the reason why that's prejudicial to the company is because we're not able to fully assess whether we're liable under the policy. That seems to be like the clause that I'd like you to hear you say, but you're not saying that. You're just saying you got the wrong information from the insured, and that's itself prejudicial.
Well, it's the principal obligation of the insured to give accurate information about the claim. If that's his principal obligation on the insurance policy, aside from paying premiums, without that information, the insurance company is absolutely prejudiced in terms of being able to assess its exposure on the claim. So it is left, because of that prejudice, the insurance company then has to go out, as it did in this case, and conduct its own investigation, hire an expert, and put the facts together on its own in order to determine what actually happened. And then, after doing that, assess whether there is a coverage for the claim under the policy. And in this case, the insurance company determined that there was no coverage because the claim was not a hit while parked claim.
Well, isn't the prejudice, doesn't it flow from the fact that safety paid the claim, the initial claim, right? I mean, safety cut a check, right?
Pardon me?
Safety cut a check, right?
Yes.
On a claim that was not substantiated.
Well, what happened was the car was brought into the repair shop, and it was initially repaired. And the repairs at that time were to the front right quadrant of the car. And it was around for $2,000. And the insurance company determined at that time that the damages were consistent with a hit while parked claim at that time. But they had no knowledge of the fact that there was actually other damage that existed. And during the repair process, that other damage was discovered for the first time. The insurance company didn't know about that damage when it cut the first check. So initially, the damages appeared to be consistent with a hit while parked claim. But during the repair process and then subsequent investigation, it was determined that, in fact, the damages were totally inconsistent with a hit while parked claim, number one. And number two, that there was, the car was in motion, and according to the expert who investigated the car, inspected the car, and wrote a report, Charles Shack, the car had hit a wooden object while it was in motion, and it was a single accident. There wasn't like two collisions or anything like that. It was one accident when all the damage to the car, including the front quadrant, occurred. So when the expert report came in, a fuller picture had been developed over what happened to this car and all the evidence that had been acquired, not only from the independent expert, but also from other people who inspected the car, including the appraiser who inspected the car, who said that the damage could not have occurred if the car was hit while parked, at least the undercarriage damage. That all the evidence showed that the evidence did not support a hit while parked claim. With respect to the other jury instructions that the appellant is contesting, he has argued in his reply that the trial court was on notice of various issues which should have been incorporated into the jury instructions. And he relies on the case of Tenzar versus Indian Pond at 491 Mass 89. And that line of cases essentially states for the proposition that if a judge is put on notice of an issue and the issue is specifically defined and amenable to a jury instruction, and the party states his position with respect to that issue, that there is an exception to Rule 51B of the Mass Rules that would allow an exception to not voicing an objection to the jury instructions at trial. The appellant has gone into several areas where he feels these issues were addressed and made known to the trial judge, mainly through motions in limine. And I would submit that those motions in limine really do not lend themselves to jury instructions, mainly because they deal with evidentiary issues, and that the issues listed by the appellant that he believes should have been incorporated into the jury instructions really have no place in the jury instructions based upon their substance, including issues which are outside of the jury's concern and were not submitted to the jury on Chapter 93A, and that would include the demand letter, the Chapter 93A demand letter, and the response thereto. I see my time is running out. With that, I suppose I'll close unless there are more questions.
Seeing none, we thank you both for your arguments.
Thank you.
All right, our final case for today is 25P684, BOSE KEINKEDE versus EMMANUEL KEINKEDE. And again, please correct me, counsel, if I've got the pronunciations wrong.
Good afternoon, Your Honors. Attorney Jake Lopez appearing on behalf of the appellant, Mr. EMMANUEL KEINKEDE. Also, I learned the pronunciation just yesterday, so I'm also learning as well. This afternoon, Your Honors, I'm hoping to address 4 issues regarding the trial court's decision in the divorce proceeding between Mr. KEINKEDE and his ex-spouse.
I do want to remind you that the case is partially impounded, so.
Of course. Yeah. Sorry. I'm hoping this afternoon, Your Honor, I might be able to begin with issue number 2, which is regarding the sanctions issued against the appellant. As the court is aware, the first day of trial, I believe the night before, the appellant had notified the parties via email that he was unfortunately unable to attend the first day of trial as a result of a hospitalization. In response to proof of his hospitalization, the appellant had submitted, I believe, discharge papers from Tufts Medical Center, dated and timed showing that he was in fact hospitalized. Now, the trial court made it clear that the standards of a pro se litigant, such as my client, is bound to the same standards as any regularly practicing attorney with regards to appearing in court. However,
I'm sorry,
yes.
are those discharge papers in the record?
I don't believe they are, Your Honor. I apologize.
As the judge entered an order requiring your client to produce documentary evidence of his alleged hospitalization, discharge papers, and doctor notes, and I just, since this is an issue, I kind of expected, if there were that, if evidence was presented, I'd expect to see it.
I apologize, Your Honor. I'm not too sure if those documents are in fact in evidence or not, but I guess my point in trying to make is that as a pro se litigant, again, we understand that he is bound to the same standards as any long-standing practicing attorney. He tried his best to comply with the court standards in terms of appearing in court in time and making a timely notice for his absence. The reason for his absence isn't anything, strange or out of the norm. He wasn't attending a ball game. He was hospitalized, and in my opinion, I believe that had he arrived in court on the first day of trial after being hospitalized, he most likely would have been able to have his fair day in trial. And so having him on top of ongoing debt, obligations, being in sole custody of their child, being retired, having these additional, I believe it was $280 for lost wages of the ex-spouse, as well as $3,800 in court fees, I believe that these are but unfairly burdensome on someone who's already struggling. And so I hope that Your Honors might find that in an attempt to comply with the standards, he did his best that he could. And I think evident by the transcript as well, it's clear that as a pro se litigant, he may not be aware of all the regulations that he must adhere to. Flipping now to my first issue, which is that we're hoping to find that that you might find that the trial court had abused their discretion in compelling the appellant to select the 100% joint to survivor annuity and also ordering a transfer of 65% of his entire interest in the central pension fund.
I understand that ordering the husband to choose that joint and survivor annuity, 100% option, reduces the payment to the husband while he's alive.
Correct.
But what is the financial prejudice to the husband of ordering the transfer of 65% of his interest in the central pension fund to the wife?
Right. It's my understanding, Your Honor, that there was a total of, I apologize if I don't have the numbers correct, there was a total of $275,000 in the central pension fund with around 240 having accrued during the marriage and around 34,000 having accrued premarital. Given the fact that the court's rationale in choosing to both compel him to select the 100% joint survivor annuity as well as transferring 65% of the central pension fund, it seems to largely come from, and something I know I have to address, the elephant in the room, probably the size of this courtroom now, is the dissipation of funds. I believe $250,000 is what the appellant had transferred towards the end of the marriage before divorce proceedings were filed. In the court's rationale, they seem to justify this harsh transferring of the 65% of the central pension fund, as well as the joint survivor annuity, selecting the 100% plan based on this gross dissipation.
Apart from the reason for it, how does it harm the husband to have 65% of his interest in the fund transferred to the wife? I understand, given the payout order, he's going to get less per month.
Right.
But what is the financial significance of a percentage ownership interest?
I understand, Your Honor.
That only if the payout doesn't continue for some reason?
So I think, if I'm understanding your question correctly, Your Honor, the appellant currently is facing much outstanding debt with a landlord. He is facing currently, he's retired. And I know that the court makes a note saying that they're suspicious of his retirement announcement, saying that he retired shortly after the divorce was filed. He was 64 at the time, Your Honor, and he doesn't have much income coming in. On top of, he has, I think, around $200 possibly of Social Security benefits. He has, again, this outstanding debt. he's not working and doesn't plan to return to work. He has a $21,000 obligation owed to a landlord. He's taking care of himself as well as providing sole custody over their son and providing financial support for 3 of his additional children. I think that the burden comes from the fact that he's already facing a reduced amount of income coming in weekly that he can expect.
But does he have the option under this plan to take a one-time payout of the total value or some percentage of the total value? You know, whether it's 243 or 275, as opposed to taking the monthly payout over time? Is that the prejudice to him, that he cannot take as much of a payout as he could have otherwise?
I believe so. So I think, I can't really speak for the Central Pension Fund, unfortunately, but at least for the joint survivor annuity, I do know that selecting a a reduced amount, I believe 50% was one proposed, he would be receiving more in a monthly income, I believe.
Right, no, that's the payout. I think Justice Sachs is asking, what difference does it make how much of the interest in the pension fund is assigned to the wife versus him? What difference does that make, unless you're thinking about a potential, I'm going to cash this whole thing out and take the cash value? Is that?
I think,
right? Is that the only scenario where it makes a difference as to how much is of the interest is allocated to her versus him?
I think that the main issue that the appellant has with this transferring of the 65% is that much of that value is what was accrued prior to the marriage.
No, but what difference does it make in terms of who gets money, right?
No,
just assuming that it stays there, what difference does it make who's assigned the interest? Does it affect how much money they get?
I imagine that it would affect how much money that they get. I imagine that it would affect how much he received. Again, I think just the overall narrative that I'm hoping to paint is that he has a reduced income as it is right now. And I think the Central Pension Fund would greatly go towards helping and solving much of the financial issues that he's been having.
I mean, his reduced income is because he stopped working.
He stopped working, but he was also at the time, I believe he was 64 when he announced his retirement. He's currently 70. He's been, I think he not to get into the history of the appellant, however, he doesn't have any expectation of receiving any additional income.
Right, but the judge found that the husband's decision to retire was deliberate to reduce his financial obligations in the divorce settlement and to limit the financial support available to wife and the children, right? So she I think it's a she found he left his nice job at Harvard and in order to deprive the wife of assets.
I know how.
Tough finding for you.
Right. No, I know exactly how it looks, and I knew coming into this that this is going to be a big thing to have to cross. I think if I can just steer a little bit, Your Honor, I think part of the division of assets is that we want to try and focus on the present and future needs of the parties. And while at the time before the divorce, during the marriage, the appellant was working and making around $100,000 a year, while the wife unfortunately struggled to really gain employment and has come a long way from their time during the marriage and is now working at Dunkin' Donuts and has a steady income coming in. I think as it stands right now, despite how much the appellant was making during the marriage, right now he is, I hate to say it like this, but he's in the one of the financial support as it stands. I understand that the wife has sole custody over the 3 children. However, she's currently employed. She has more Social Security benefits for each of the children. I believe, as it stands right now with the joint survivor annuity, I believe she would be having around $1,300, I believe, upon the appellant's death. And with the Central Pension Fund, I believe as well, they will be also having some more money coming in with that. It's not a pretty situation by any means for someone who was making so much money during the marriage and suddenly retiring. It's something that I don't even want to try and dispute that at all because I know how it looks. Yep. But I think, in trying to stay the course or the theme of division of assets and in divorcing, you want to try and sort of focus on the present and the future needs of the parties. And as I've mentioned before, right now, the appellant is facing, I think, around $21,000 of outstanding debt, these $4,000 of court sanctions for missing a day of court. He already has an oppressive joint survivor annuity plan for him. He's in sole custody over one of their children, responsible for all of the insurance, medical, dental costs associated with that, and continues to make financial support decisions, or continues to financially support his other 3 children. I hope I don't know if I apologize. So I hope I've covered why I hope that the appellate court will find that the trial court had abused their discretion in finding that the appellant should have chosen the 100% joint survivor annuity, because there were alternative options that could have been selected that would not have been as burdensome on the appellant as the 100% selection, as well as the transferring the 65% of the pension fund. Now, moving on to my third issue, I was hoping to find that, or hoping that the appellate court might find that the trial court had abused their discretion in finding that the appellant must be solely responsible for and maintaining medical, hospital, and dental insurance coverage for only one of their children. One concept of divorce that I hope I've been trying to sort of establish is that, you know, there should be an equal share of obligations, outstanding obligations, and as it stands right now, with the appellant only being responsible for one of the children's, all of their hospital, medical, insured costs, while the wife is responsible for the insured hospital, medical, dental costs of her 3 children that she has custody over. We were hoping to find that there should be an equal share and obligation of all the insured costs. As it stands right now in the order by the trial court, both parties equally share responsibility for all the uninsured financial obligations for the children. And so, in sort of trying to keep to a theme of equal distribution of all these obligations, we're hoping to find that the trial court should have selected an option that would have, you know, put a 50-50 split on the imposed costs associated with all the insured hospital, medical, and dental costs. Again, as it stands right now,
Parties had,
yes.
The custody arrangement was that the husband would have full physical and legal custody of one of the children, and the wife would have physical and legal custody of the other 3.
Right.
So why was it an abuse of discretion for the judge to match up the expenditures and the tax deductions with the parties' agreement about who would have custody of which children or child?
Right, and I think the abuse of discretion comes from the fact that in the face of alternatives that would have possibly alleviated some of the financial burdens on both parties, it would have made more sense, and it sort of would have been, in our opinion, more equal for the parties to share this 50-50 split of all those costs, despite what the custody agreements are based on who has custody over whom. Again, we think that having this equal 50-50 split down the middle would provide it would alleviate financial burdens on both parties while also ensuring this theme of equal distribution of the obligations in the face of a divorce. And for my final point that I'm hoping, I know is a tough one to come across, is we're hoping that it might be found the trial court had abused their discretion in allowing the appellant to only claim 1 child as tax dependent while allowing the wife to claim 3 as tax dependents. Now, in the face of his outstanding obligations and financial burdens and reduced income as a result of the retirement, and reduced Social Security benefits that would go towards helping himself and his son, we are hoping that it could be found that the appellant might be able to claim multiple kids as tax dependents. Now, I understand the custody agreement had placed 3 of the children with the wife and 1 of the children with the father, but I'm hoping that in keeping to this theme of alleviating financial burdens and sort of having an equal distribution of obligations, that the father might be able to claim another child, multiple children, possibly even 1 more child as tax dependents. And I know I'm out of time, and I hope I've addressed your questions. Thank you very much, Your Honors.
Thank you very much. We'll hear from counsel for the wife.
Good afternoon, Your Honors. May it please the Court. Chris Herbert for the appellee, who I'll refer to today as the wife. The
The Family and Probate Court achieved Section 34's goals of an equitable asset division and properly exercised its discretion in ordering sanctions, and this court should affirm. I'd like to start just by emphasizing 3 points today, Your Honor. First, given the court's uncontested factual findings here, there was nothing plainly wrong or excessive about the treatment of the husband's central pension fund. That distribution was properly tied to all of the relevant 34 factors, including the husband's asset dissipation, and properly included amounts that accrued pre-marriage under the statute and the precedent interpreting it.
What's your understanding of what difference it makes as to who has the interest in the pension fund as opposed to the payout?
Yeah, so I understand the confusion. It is somewhat unclear from the trial court's decision what it thought it was doing. So my understanding in talking to the pension expert that testified below, but unfortunately his testimony is not in because the appellant only ordered the second day of the trial and he testified at the first day of the trial. But his understanding of the order is that it'll be a monthly change going forward. So once these payouts start happening, right, there's this monthly estimated benefit of around, I believe it's $1,200 a month. 65% will go to the wife, 45% will go to the husband during his life. When he dies, the full amount will stay that, and then just all of it will go to the wife. That's my current understanding of what our pension expert believes the judge meant, but really a lot of this is going to be taken care of by the quadro process, which hasn't happened yet. So once we sort out here, whatever we sort out here, we're going to have to go back down and fill out this QDRO form, which will then talk about exactly where the money goes and when. So my understanding is that right now we understand that it's going to be a monthly change, but it might be something different.
And that's distinct from the joint and survivor annuity issue? That's a different payout?
Right. So the way I understand this is that the election will be made first, right? So this 100% joint survivor annuity. And so that defines the benefits that are going to be paid during the husband's life and after the husband's life. Mm-hmm. And those payments are going to be the same before and after. So it's going to be, let's call it $1,200. And so during the husband's life, 65% of that $1,200 monthly will go to the wife.
I see.
And then after the husband passes away, the wife will get the full 100% of that $1,200 until she passes. So that's our understanding of what the judge ordered. There's still this quadro process that needs to play out where it's going to go through those intricate details, but that's our understanding of what the judge was trying to do through her order. Also my understanding, Judge Sachs, to your point, is that there is no ability to do a lump sum payout here through the central pension fund, and again, that's based on my understanding from the pension expert, in case that is helpful for you as well. So I just want to circle back to, I'll stay on this topic for a little bit, on the pension fund. So the way I read the husband's briefs is that they're really just challenging the weight that was assigned to the dissipation. They're not contesting the factual finding that he dissipated. They're not contesting the factual finding that he retired to deprive the wife of assets. And so really their only disagreement is weight. And if you look at cases like Early, when you're talking about assignment of weight, that's really, really broad discretion that courts have there. I also just want to point out that when we're talking about how much income the husband is making in a fair and equitable asset distribution, what they're also not contesting is the finding that the $250,000 wasn't spent and he still has access to it. So when we're talking about his $600 a month income, or excuse me, yeah, I think it's a month income, we're really not talking about $600 a month income. We're talking about what he's bringing in now, what he will bring in from his 35% of the pension, and also the $250,000 that he has access to somewhere else that he successfully hid from the wife. So when we're talking about equitable distribution, I would say that we've pretty much achieved that here, Your Honor, and the court did not abuse its discretion in doing the 65% split or in ordering the 100% annuity. Unless the court has any further questions on the pension, I want to talk briefly about sanctions. One thing I want to reiterate is that the paperwork that the husband provided here is indeed not in the record. And so because you don't have that paperwork before you, it's really hard to say that the court committed an abuse, or excuse me, clearly erred in finding that the excuse was not legitimate. And so I think when you start from that premise, then it follows through that this was clearly well within the court's discretion to say, okay, you have to pay the costs that were reasonably incurred for your failure to appear and not adequately explain that you couldn't appear. So I do have access to the paperwork. I have seen it. I believe, and I don't want to go outside of the record or anything like that, but it wasn't a full hospitalization. It was a brief visit to the ER for a couple of hours. And so to say that he couldn't show up at trial the next day or the day after seems a little like a stretch to me, and I think the court very well properly exercised discretion there. I also just want to point out that there is a little bit of it seems to me that the fact of sanctions being ordered is the husband's primary point and not so much the amount. There is a little bit of dispute in the amount, I think, when it comes to the brief. I didn't hear any of that today, but I do just want to point out that there was also a motion filed with an affidavit to attest to the reasonable costs that counsel and the expert kind of incurred out of pocket for being at trial that day. So there was properly supported evidence in the record as to what these amounts were. These sanctions are properly tied to the loss incurred. And are not unduly punitive, because sanctions also can be punitive, right? So to take a step back, there's this argument on the pension fund that the split is unduly punitive. There's also the second argument that the sanctions award itself is also punitive. Well, sanctions, of course, are meant to punish and also are meant to compensate. So when you split that out of Section 34 from the kind of equitable considerations that you do when you're doing asset division, this was clearly properly tied to the amounts lost by the parties who suffered and also clearly done to deter and punish, and that's completely fine when you come to sanctions. The last thing I'll say on the final points, Your Honor, about the health insurance and the tax distribution, it's not even clear to me that the husband asked for this treatment below on anything. And so, again, it's hard to say that the judge committed an abuse of discretion by not ordering something that the husband didn't ask for below, especially when those kind of treatments accord with like the basic rules of you get to take the benefits of the children in your care and you get to pay the benefits of the children in your care. So when you look at it as these kind of default rules and then think about it in the sense that the husband never asked to deviate from those default rules, there's plainly no abuse of discretion there. And unless Your Honors have any further questions, we'd largely just rest on our briefs.
Seeing none, we thank you both for your arguments. That will conclude our session for today. I'd like to thank our court officers and law clerks and other court personnel for their assistance. We are just going to go briefly in back and then come out again and talk to our BU law students who are here observing, if they aren't too hungry to go get lunch. But with that, I'll say our formal proceedings for today are adjourned.